Okay. All right. This is the guy that was hunting beaver with a firearm and a light.
No, it was his cousin shot the beaver and threw it in the back of his truck for disposition.
Okay, so he was convicted of possessing a beaver without a license?
Right.
All right.
His position, but he had a firearm with him and the beaver carcass with him.
Okay. I see what you're saying, yeah. And no cousin in the truck.
No cousin in the truck.
All right. We'll take this up at 1 o'clock. Thank you all.
All right. I don't know what's going on. Let me go find this chamber. Is it happening? Is this going on? I don't know. I'm going to turn my camera off and go look. Where's Andrew when you need him? Andrew missed not only that opening, but what did he miss earlier? Oh, yes, Ms. Bush. I'm going to have to fire him again.
Trial. This is crazy. Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore? I never want to hear it again. Sweet Jesus. You're not a whore? Not a whore? You're not a whore? I never want to hear it again. It gets worse.
There were drugs involved that were given to me that ended up being glue. Like, I smoked some glue and stuff. I thought I was smoking crack.
Let's go. You didn't say the cat jumped on his meter, did you? Sit down and shut up. Shut up. Shut up. Cat jumped on his meter. Cat jumped on his meter. Shut up. Cat jumped on his meter. Cat jumped on his meter. Shut up. Cat jumped on his meter. Cat jumped on his meter. Shut up. Cat jumped on his meter. Cat jumped on his meter. Shut up.
Can you just let this go for once? For once? Once?
Okay, bad doing no.
Mr. Sharps.
Not a whore?
Mr. Sharps. Mr. Sharps. Mr. Sharps.
Everybody fucking dance. You're not a whore? You're not a whore? I never want to hear it again. You're not a whore? You're not a whore? I never want to hear it again.
Now, if anybody thinks this is okay, I am in the wrong.
I think we'll need your laptop anyway, because the audio isn't working with this. Right. No. Remember, it's going through that speaker down here.
The
that's okay. It should be able to
Okay.
hear you.
I really want to see face tat now.
All right, folks, don't be smoking, don't be eating, don't be in a moving vehicle. Make sure you have a pen or pencil ready to write. You always have something to write when you come to court. We will now be on the record.
You don't have the pen on, sir.
Make sure that you have your volume muted, so when I'm taking up a case, I don't get interference from your private conversations. Is Kylie Parsons here? Is she in custody?
I'm appearing for Kylie.
All right. We'll go on the record in case number 2024 TR 523, State of Kansas versus Kylie Ann Parsons.
Oh, sweet Jesus.
County
We have
Attorney Jill
we have a
Gillette
soft
for the state. Attorney Kent Collins appearing for the defendant. I understand that she does not appear in person, Mr. Collins.
That's correct, Your Honor.
I typically have them appear in person, but looks like she's charged with speeding 80 and a 65. One, two, three counts of
I thought
purchase.
Adolf there said he was appearing
I'm not
for
sure
Kylie.
how that is,
All right.
but 3 counts
Never
of
mind.
purchasing, possessing, or consuming alcohol by a minor
False fizz
and
alert.
transporting an open container of alcohol. All counts to have occurred in Greenwood County, Kansas on July 3rd of 2024. Ms. Gillette, can you tell me how it is or what theory it is that one person possesses alcohol times 3 on the same day?
3 different kinds of alcohol, Your Honor, in the vehicle.
Okay. Counsel, I presume that since these are all misdemeanors and your client's not here, that you wish to enter a plea of not guilty to each of these counts?
That's correct, Your Honor.
And do you wish to have this set for trial? Or do you wish to have this set for status?
Let's set it for a status conference.
Missy, what do we have available for that? Probably about 30 days out?
Correct.
Goes on the traffic docket, and I don't have anything available till September 27th.
Well, Ms. Gillette, what does your office wish on this traffic docket? Misdemeanor docket.
It's fine either way, Judge. I'm not gonna complain about either one of them.
All right, so Missy, whatever you want to put it on, we can do it on whatever's more convenient.
September 27th, that's a Friday.
That is, and we usually do them Friday mornings.
Okay.
Missy, what time are you looking at on September 27th?
9 o'clock.
That's good for me.
Very well, we'll set this for September 27th at 9 a.m. I would like for your client to be here, and I don't think she's made bond, has she? Let me look.
Will this be by Zoom hearing?
It will be by Zoom, and when she needs to make arrangements to, well, I guess she won't have to. It's not an A or B that she would have to appear for to get those taken. So, all right, anything further from either party?
No, Your Honor.
Then we will be in recess, and Mr. Collins, you're excused unless you're here for someone else.
Thank you.
You're welcome.
I was told she'd be live at 1:30. I was wrong as usual.
Let's see, Mr. Rapp, you're here for whom? Oh, Perez Beal?
Yes, ma'am, and he's in custody.
All right, well, let's take up the one that's in custody first, and
Yes,
that
ma'am.
is Dakota Koenig will be on the record in case number 2024 CR 105 and 2024 CR 1. I'll strike that. We're here on 2023 CR 117 and 2024 CR 105, each captioned State of Kansas versus Dakota. How do you pronounce your middle name?
Naston.
Naston.
Yes.
Dakota Naston Koenig,
Yes.
County Attorney Jill Gillette for the state, and Mr. Koenig in person, in custody,
Oh, good Lord.
and pro se.
I don't even know
Mr.
what's going
Koenig,
on.
let's look at 23 CR 117. That is theft of property and services, 2 counts. You did fail to appear on that
This is what you get when
recently.
you name your
Well,
kid Dakota.
My lawyer sent me a paper that says my court date will be on the 7th, and I scribbled the court date that you gave me off, and then I put the 7th, and yeah.
All right, so your attorney.
Oh, good Lord. I thought
Mr. Paul was here on June
when I
21st.
first talked.
Can I have it
I was wondering if he was
rescheduled
playing a game, but
Paul?
I don't think so.
And can I get all out so I can go to my job and pay my fines off?
Well, let's see. On the other case, the 24 case, the felony with the possession of meth, that was also set for August 2nd, and you failed to appear.
Those two cases was on the same case, and
okay, even I'm not laughing here.
Said my court date was on the 7th, the day after my birthday, and yes, today is my birthday.
Oh dear.
And I have probation tomorrow. So.
All right, so you failed to appear on these 2 dates, and your attorney gave you some kind of correspondence that said your court was the 7th?
Yes, and right now my paper is at home right now.
All right, Ms. Gillette, what do you have to say about bond? That's what we're talking about is bond.
Dakota missed the 21st of June. Andy missed August 2nd. I don't know if he read the 2 to be a 7 or that's common to be a mistake, but Dakota kind of disappeared for a while. We needed to find Dakota, and he did.
Yeah, I know. There was a lot of concern as to why no one was seeing him in the neighborhood, as we might usually.
We normally see Dakota frequently. I am comfortable giving him a $2,500 OR because I don't think he's going to disappear. You can leave it at the 5,000 mark OR, but before he leaves, I want him to call Mr. Paw from the jail, and yes. I would like for him to report to one of our local CSOs. So that we know where he's at weekly, because he doesn't usually take off very far. We can
Dakota,
let her speak. Dakota, let her speak. Go ahead.
We found him pretty quickly, and he's very familiar with one of our CSOs that's had him on before. If there was to help with him and make sure that he's here for court in the future.
Well, and I think he has city court and probation going on, don't you?
He does, yeah.
Okay. Can you pass a UA today?
Yes.
You don't have any meth in your system, you don't think?
No.
No
No,
marijuana?
ma'am.
Marijuana?
Nope. I'm clean. And my PO, my probation is tomorrow at 5. And I thought my call was at 1:30 on the 7th.
Okay. Are you and your dad still planning on going out of town?
Yes, we was just going to go to Sebri for the job.
All right. Well, at one point you were talking about leaving the state, but that one didn't work out?
No.
Okay. All right. Well, it sounds like you're going to stay local and be able
Yes.
to find you. I'm going to just reinstate the existing bonds. But if you fail to come to court again, it's going to be more severe. So you make
Yes.
sure that you can read Mr. Pa's handwriting. If he writes a 2, that you know it's a 2 and not a 7.
Yes.
Mr. Pa is usually pretty on top of his business, and he's a human. He's not perfect, so it's possible he gave you a 7. But I think it's also possible that, like Ms. Gillette
That's
said,
what we're
the way
waiting for,
people make
Colleen.
some of their letters, it could have come across wrong. And then again, when you get home, look at your paper. It may have said something you don't remember. In any event, I'm going to release you, and I'm going to order that you reappear at the next available date that Missy will give us for these preliminary hearing control settings.
September 13th at 1:30.
At 1:30.
September 13th at 1:30. That's a Friday?
It's Friday the 13th, Judge.
That's what I was
Wow.
thinking. You
Oh,
remember
wow.
that, Mr. Koenig. You remember that, September,
Yes.
Friday the 13th, so you won't be confused.
Do
And
you want
call Mr. Paul before you leave?
him to check in with anyone else besides Mr. Paul?
I'm not gonna do that. I'm gonna let Mr. Paul take care of it.
Okay.
But you
Did
do
Mela,
call Mr.
did Mela or the jailer write that down for you?
Yes.
Okay.
As long as jailer, you can write where he can read it.
Yes.
Write neatly and clearly for him. All right, none of that sloppy stuff. And I have no idea what your handwriting is like. I imagine it's very good. All
No,
right.
Your Honor, I always type up all the papers like that, so there's no mistake.
Well, that's a good idea. All right. Well, thank you, Deputy. I appreciate it. And Mr. Koenig, I'll see you, Lord willing, September 13th at 1:30.
Yes, yes.
Okay. Stay out of trouble.
Yes.
Okay. See if she's going to bring back Mr. Presby. That's not Mr. Presby.
Attorney President.
Is it? What's your name, please?
Well, that was a strong start.
Antonio Presby.
Okay, I think you've had a haircut since I saw you. I wasn't sure if that was you or not.
Yes, ma'am.
Okay. We're on the record now in 2024 CR 141, State of Kansas versus Antonio Manuel Perez Beal. Please announce appearances.
May it please the court, the state appears by Gillette County Attorney.
John Rapp appearing via Zoom with the defendant, who's also on Zoom, but present from the Greenwood County Jail.
Okay. We are looking at, gentlemen, as you probably know, 4 counts of violating a protection order. And the first counts 1 and 2 allegedly occurred in Greenwood County on July 2nd, and the 3rd and 4th one on July 5th. And those are each Class A misdemeanors, which means each one can carry up to a year in the county jail and up to $2,500 fine. Counsel, does your client wish to enter a plea of guilty today or not guilty today on those?
Please, Your Honor.
And do you want a bench trial or do you want a control or status hearing?
If it would please the court, I would respectfully ask for a control setting for now.
That'd be fine. And Missy, what do we have available?
How about September
you.
17th at 3:30?
Is that date, September 17th at 3:30, available to everyone?
That's okay for the defense, Your Honor.
Very well. Then I will set this for a status or control hearing for September 17th at 3:30. That will be by Zoom again. So you have your counsel, you have your court date. Bond has not been set. I presume parties want to be heard on that.
I would like to be heard, and one thing I want to make sure this court is aware of, we had a bond hearing last week before Judge Hart, and he set a bond at $75,000 for the other cases with cash or surety. We have a bondsman lined up. There's also a number of other requirements that Judge Hart had in his, and I'm asking this court to adopt Judge Hart's ruling. So we pay one bondsman one time.
Well, you win some, you lose some. Yes, thank you, Jalapeno, for the intro. The all beaver intro was fantastic. If you weren't here for it, well, where the hell were you?
Can I have parties announced for the record for the state,
Jason Gear, how you doing?
for the defense?
I can go down for Miss Herrera.
And are you Ms. Herrera?
Yes, ma'am.
Counsel, in each of the cause numbers, have you received all of the discovery?
Yes, Your Honor.
And did you review it with your client?
I did.
In each cause number, the court will find that the state is in compliance with discovery. Ms. Herrera, in each of the cause numbers, did you review what's entitled true bill of indictment with your attorney?
Yes, ma'am.
And did you understand it? Counsel, in each of the cause number, do you waive the reading of the indictment?
We do waive reading.
All right, stating cause number ending in 8-9, are you proceeding on the indictment as presented?
Your Honor, we'll favor Peter. Herrera.
Any objection?
No objection.
And in the cause number ending in 8-8, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the enhancement paragraph also. No objection.
Ms. Herrera, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney?
Yes, ma'am.
Did you understand it?
Yes.
Did you sign it in all the appropriate places? All right. Did you understand in the cause number ending in 8-9, you're charged with the offense of robbery and also with the offense of robbery in the cause number ending in 8-8? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea.
Yes, ma'am.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent.
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Do believe she's competent, yes.
All right, and the court will note for the record that the defendant's competency was restored on June 3rd, 2024. Ms. Herrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. There are no applications. The cause numbers were run concurrently, and the state is taken in consideration 2022 CR 11787. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That is the plea, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No more. Your Honor.
Then in the cause number ending in 88, how do you plead? Guilty, not guilty, or no contest? And in the cause number ending in 89, how do you plead? Guilty, not guilty, or no contest? State, any evidence to support the defendant's plea?
Yes, Your Honor. In each of the cases, state exhibit number 1 with all its attachments. We reviewed that, Your Honor. We have no objection.
All right, state, you may be excused. Thank you. Mr. Herrera, did you review the document entitled trial court did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments in each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just ask that the court go with the plea agreement.
All right, in the cause number ending in 89, the court will follow your agreement. Court will sentence you to 8 years in the prison, give you credit for any time served. This is to run concurrent with 2022 CR 11788. Take in consideration 2022 CR 11787. And the cause number ending in 88. The court will find you guilty, sentence you to 8 years in the prison, give you credit for any time served. This will run concurrent with 2022 CR 11789 and 2022 CR 11787. And based upon her previous incompetency, I'll request that they place you in the mental health unit. Whether they do that or not, it's completely within their power. I have no jurisdiction to force them to do that, but they'll at least see in the judgment that there are mental health issues.
Thank you.
You're welcome. All right, is there anything else with regards to sentencing in either of these cause numbers?
Nothing else, Your Honor.
Ms. Herrera, in each of the cause numbers, did you review the document entitled Trial Court Certification of Defendant's Right to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. All right, we can go off the record. I can definitely tell you, you're not going to be allowed to possess tasers. You understand?
Yes, ma'am.
And I understand that you have mental health issues, but that doesn't excuse or negate what you're doing. You understand? From here on out, if you pick up another felony case, your minimum is going to be 25 years. Do you understand? Do you have someone who, a support system once you're released?
My daughter and my son.
All right, good luck to you, okay?
Thank you.
You're welcome.
Thank you, Judge.
You're welcome.
Thank you.
Oh, sure. Yeah. Yes, we're gonna take that up. All righty. All right, who else do you have, Mr. Brenda Rodriguez? Come forward. Mr. DeLeon, you're gonna be here tomorrow. You want to recall it tomorrow?
I don't want to recall it tomorrow, Judge. We actually, I do need a little bit more time to have substantive arguments or communication with the state.
All right. Could you hand me a reset form, please? All right, I can set it for August 26th, 27th, or 29th.
In California at that time with a vacation letter, Judge,
Oh.
I could file a motion for continuance if the.
Oh, well, this is not a trial setting,
So,
and you have never asked for a reset before, so you're fine. All right, so you want to do it the week of the 19th? Is that too soon?
once again, I've got a vacation.
Oh,
letter.
when do you leave for California?
I leave for the, I can do the 19th. I leave for on the 20th.
All right, do you want to come back on the 19th?
Yes, I do have other settings for that date, so that'll be fine.
All right,
August
well,
19th.
we'll bring you back on August 19th. All right, and you can have your client put her email address on that. Once you sign that, you're excused.
Thank you, Judge.
All right, before you leave, Mr. DeLeon, do you have anyone else on the docket?
Nothing else till the morning, Your Honor.
All right, is there anyone else who's here? Hardaway, what is happening with this case? Could I see the file on Jasmine Hardaway? Yes, what's happening?
She should go.
She's right there.
Oh. Where? Oh, okay. Yes, Your Honor, I think we have a potential resolution of all these cases.
Okay.
Mr. Edelman and I had a discussion about it. It's a little bit off the beaten path. I wonder if you wanted to do that in court or do it in the back.
You want it in the back.
Well, the procedure to employ in this particular case.
All right.
You cool with it?
Yes, you all want to come back tomorrow?
I think we can resolve it today if you think this is the way we can proceed.
All right, if you'll just give me a moment.
Sure.
Okay.
We'll be here. Me and Mr. Doesn't he look like the governor of Minnesota?
Oh,
Chump-
well, why is he here? Shouldn't he be on the campaign trail?
I was asking.
There is no schedule at Law Talk Nation. You can only pay, get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike. We got pre-trial on the dial. Planning always make your chest smile. The pros say can't ever share a file. Defendants are always in denial. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day on Law Talk with Mike.
This is dedicated to Kim.
Courtroom is always popping up. You have a failure appear and you scoff. Judge Simpson is never going soft. Webster is always showing off. We are heading into that soft six summer. Did you miss the line? That's a bummer. The soft six never get smarter than dumber. He's not the man, he doesn't a number. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day of law someone like. Courtroom is always popping off. You have a failure to appear and you scoff. Judge Simpson is never going soft. Webster is always showing hard. We are heading into there is no. Number one, wrong. Know what I'm saying? Number one, wrong. Know what I'm saying? We are the law talk with my crew. Number one, wrong. Know what I'm saying? 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 Number one.
State, do you have any opening statements?
Not at this time, no.
Defense?
No, no.
All right, State, you may proceed. Call your first witness.
The State Call Sergeant Bianca Martinez.
State would like to say na boo boo.
All right, you're still under oath. If you could state your name for the record, please.
Bianca Martinez.
State.
At this time, the state's gonna offer state's exhibit number 109 into evidence. It was USA insurance documents related to this case there was a business records affidavit, a notice of business records affidavit that was provided to defense about a month ago.
This is some sort of sentencing phase of trial.
I could take a big defense.
Yeah, may we inspect it, Your Honor?
If they elect to have the jury do the sentencing, apparently in Texas, you get this. I don't know. I think other states have. I mean, all the states are a little different in how they do it, but similar. This isn't the way I've seen it done in Illinois, but that it doesn't make it weird to me. It's just a slight variation.
Your Honor, I apologize. We haven't seen it in this form, so we didn't.
What form have you seen it in, council?
Well, they gave it to us in a PDF form, but we haven't seen it in this binder, and we don't know if these are the same documents we were given.
All right, approach, please.
Which is number one, wrong.
He's still on the love boat. A decent guest. Might even be his wife's. I was kidding, of course. Oh yeah, there's no way his wife's on that cruise. It's called the Love Boat, people.
Any objections?
Yes, Your Honor, the defense objects because this contains hearsay within hearsay, so even though it may meet the first level of hearsay under the
Ooh, double hearsay.
Business records exception, there's not an exception that's been laid for the hearsay within hearsay that's contained throughout these documents. And so we'll object on that basis.
State.
But Your Honor, I can get to establishing the hearsay within hearsay portion of that. If I get a moment to speak to this.
Yes.
Sergeant Martinez, have you had a chance to look over the documents that are contained in that binder?
Yes, sir.
Have you had a chance to listen to the audio recording that's accompanied with that was accompanied with the documents in that binder.
Yes, sir.
And what was that audio recording?
The audio recording, what was it of?
Yes.
It was a conversation between the defendant and the USA.
Okay, it's straight to the
claims
spanking machine
representative.
for you.
And there's a transcript in 109 of that conversation. Have you been able to compare the transcript and the recorded conversation to one another?
Yes, sir.
And
You
were able to
too.
recognize the defendant's voice?
Yes.
And were you able to follow along with the transcript along with the audio recording?
For the most part, yes.
What do you mean for the most part?
The audio recording was a bit choppy, but I was able to follow along with the written transcript.
Was that written transcript, is it a true and accurate copy of what was in that audio recording?
Yes, sir.
Defense?
May I take this witness on board? Ida?
Sure.
So Sergeant Martinez, I think what you just stated was.
You may
could-
have a seat.
Oh, sure.
Yes.
I think what you stated is that you couldn't hear the recording in some parts, so you followed along in the transcript. Is that right?
No, sir. I followed along simultaneously.
Yeah, and maybe I misheard. Did you testify that the recording was choppy and that you had trouble hearing the recording?
A bit choppy in some parts, yes, sir.
Right. And you didn't do the transcript, nor do you know who made the transcript?
No.
And that transcript is not an official court reporter's transcript or certified as an official transcript for court purposes.
I'm not aware of that.
And the as far as what was choppy, I guess when you're saying that it was choppy, you're saying that you had difficulty hearing, but you looked at the transcript, which helped you to be able to hear it.
The audio just cut in and out very briefly at times, but I was still able to follow along with the written transcript.
But without that transcript, you would not have been able to hear where it cut out.
As far as the words,
Yeah, if you didn't have the transcript, you wouldn't have been able to hear it at the parts where it was cutting out.
I don't believe it cut out long enough at any point in time where it cut out whole words.
Good answer.
But there were partial words, I guess, and I'm just trying to understand. So there were partial words that were cut out that you weren't able to hear, but the transcript aided you in being
Yeah.
able to hear what those words were.
You just didn't get the answer you
I
wanted.
feel like for pretty much the entirety, I was able to recognize the words that were on the written transcript and the audio words from the audible transcript.
Yeah,
or
I've
the
done
audible
this before,
recording.
son.
Understand. Your Honor, I guess at this time, that's not the only hearsay within hearsay issue, but I do believe that including a transcript that is not a certified transcript, that this witness cannot testify where the transcript came from, who did the transcript, and all of those things. There's rules about transcripts, and when they're offered in a court of law,
Yeah.
they have not followed
Yeah.
those rules.
She
and
patched
so
the holes you were
therefore, we
trying
do
to
not
poke.
believe that that should be admitted. Additionally, that's not the only part where there's hearsay and hearsay. There's a lot of letters back and forth from lawyers. There's legal documents. There's other things that all qualify as hearsay within hearsay. I don't.
With regards to the letters, can I have parties approach, please?
Ma'am, are you a whore? I object to the relevance of that, Your Honor.
All right, what?
I'll tie it up real quick, Judge.
All right, go ahead.
You're not a whore?
Say the words that she said, or
Sure. I need for you to tell me what went on.
that I'm not on that whole shit. I'm not with that whole shit.
right, State, you may proceed.
Yes, Judge. Guys. So, Dr. Martinez, have you had an opportunity to look at the documents that are involved in State 109?
If you're referring to that large binder, yes.
109A resides. Well, I'm going to show you part of what's in a 109A. Have you had an opportunity to see this email?
Yes.
And who is the email sent by?
It's sent by the defendant
And who's it to? Can you
to
tell?
USA to claim their claims.
Okay, would you be able to read what the email says?
Your Honor, I'm sorry, I object to hearsay. I'd like to take the witness on the voir dire about how she could identify that that email was sent by the defendant.
All right, the objection to hearsay will be overruled.
Speculation as well, as far as the fact that she can't identify. We don't have any evidence.
All right, State, lay the foundation if possible.
Are there any other emails here where the defendant identifies himself?
Yes.
Okay, and what does he identify himself as?
By his name, Alexander Castro.
All right, objection is overruled. You may proceed.
If you could read, just beginning from where I'm pointing.
Sorry, the font's little. Hello, anything yet on the photos or even a response? I have tried calling, but have not yet been able to speak with her. Is there anything you can do on your end because this has dragged on long enough? I will keep calling, but maybe you'd be able to as well, or be able to speak to her supervisor. The number is 210-207-7385. Detective Ramirez or the SAPD case number should get you in contact with someone. Like I said, I will keep trying as well. Thank you.
So it mentions there that it's been dragging on for long enough. What was the date that this email was sent?
This date shows September 13th of 2022.
And how long after the crash here was this sent?
That would have been less than 2 months.
And there's a phone number that was given out in the email. What was that phone number?
That's the phone number to the traffic investigation detail.
And have you had an opportunity to look at the other emails that are contained in this binder?
Yes.
And in States 109A, are there other conversations about reaching out to you regarding photos for processing the claim?
I object to hearsay if it's not the statements of the defendant.
All right, if it's not the statements of the defendant, that will be sustained.
And are these emails sent?
I'm sorry, may we have an instruction for the jury to disregard?
All right, ladies and gentlemen, you'll disregard the last question. You may proceed.
If it's Mr.
Denied.
Does the defendant in other emails talk about the claim being processed?
Yes.
And does it create context for what he's talking about here about the claim dragging on for too long?
Yes.
Your Honor, I just object to hearsay again. It's a backdoor way of hearsay where he is speaking about things that the court has sustained.
All right, overruled. You can answer the question.
Yes.
And I'm going to show you one other section in States 109A. What am I showing you here?
This is the transcript of the audio conversation that I reviewed.
And have you had a chance to read the transcript recently?
Yes.
And what detail? Well, one, who's a part of the transcript?
So it's the claims representative from USA, and it's the defendant, Alexander Castro.
And does it indicate when did this conversation take place?
Uh,
In here.
So here it's the USA representative speaking, stating who she's speaking to, and she states the current date for the conversation is July 29th, the time at 2:11 p.m.
What year? July 29th of what year?
No, I'm sorry, July 29th, 2022.
So how long after the crash was this?
That would have been 7 days later.
Okay. And in this transcript, is the defendant asked about what happened in the crash?
Yes.
And what does he indicate?
Basically, he gives similar details that he He's not sure about a lot of the details. I don't know specifically what you're referring to.
Well, does he give an indication as to where he was going?
He said he was going home.
And you've had a chance to review Officer Morgan's body cam.
Yes.
And is what he said here in that transcript, is that different from what he said on the body cam?
Yes.
Well, what did he say on the body cam?
He told Officer Morgan that he was going to get a friend.
And are you aware, where does the defendant live? What city?
At the time of the crash, he resided in Shirts.
And in order to get home, would he have had to have taken 281 to get home?
No.
So speaking of defendant's location.
Can you wait until you get in front of the mic?
Yes, ma'am. I'm going to show you what's going to be marked as state exhibit number 110. Do you recognize what this is?
This is the search warrant I filed for the defendant's vehicle.
Well, what specifically were you looking for in the defendant's vehicle?
I was requesting to retrieve, so the defendant's vehicle has two different modules. Aside from the airbag control module, there was a Bosch multimedia module and an LG OnStar module. So I was requesting to retrieve those two modules.
Well, can you explain, why would you want to get those two modules?
So the information that they store, those modules specifically are for the infotainment center, and most vehicles are in the center console area. So the large screen that everybody kind of navigates through for media navigation, just things like that for the vehicle. So all that information stored in those modules.
And have you been trained to extract that information from vehicles?
Yes, I've been certified both as a technician and an analyst.
And is this states 110, is that a true and accurate copy of the search warrant that you submitted?
Yes, sir.
Okay, and has it been altered in any way?
Does not appear in.
Your Honor, state at this time would offer states exhibit number 110 and tender to defense. Inspection.
Your Honor, we do object to hearsay, and also we would need to have a hearing outside the presence of the jury.
All right, Massey. All right, ladies and gentlemen, if you could wait in the hallway for a moment, please.
All right, the jury.
I guess part of it.
Yes. when the jury comes in, you will offer it as 109, and 109 will include the defendant's, whatever statements the defendant's made, but the part that I sustained, the hearsay objection, that will not be in the 109 that goes with the juror. So, all right. So what you'll be offering will be State's Exhibit 109. Okay. And then we'll start with this hearing. All right, so we're outside the presence of the jury. So people ask your questions, all right? And then the court will make a ruling.
Let's all say hi to David.
All right, defense. Questions?
I'm sorry, Judge, I thought they might have some questions first.
Mr. Goff, can you get the microphone, please?
Yes, ma'am. And just so I'm clear, I mean, I'm just making an assumption that they're offering this.
They've already offered.
It's cracking me up.
I thought they
You
just offered the
they
search.
offered the search warrant and you requested a hearing outside the presence of the jury. You requested the hearing, so please ask whatever questions you wish to ask of the witness, and then the court will make its ruling.
Yes, Your Honor. I think really the main question is, we have the exhibit.
I think Judge has.
Okay.
It's 110.
Thank you. 110. May I approach the witness?
Yes.
Sergeant Martinez. I'll show you what's State's Exhibit 110. And in State's Exhibit 110, do you see that you have I guess, a probable cause affidavit that you've included as part of the warrant?
Yes,
And you were here for the motion to suppress that was done last week of the defendant's statements.
yes,
And you remember when the judge suppressed the statements that he made to you because he had been in detention?
yes,
And those statements are included in 110 as part of the PC that you used to get the evidence that you got with the GPS. Is that right?
they're a small portion, but yes, they are in here.
So the statements that he made to you that have been suppressed by this court are included in this affidavit that's found in 110. You would agree with that?
Yes,
Kim is
So
just
with
seeking a
that
quiet
portion, Your
space.
Honor, we would say that the statements made, since they have been suppressed, that they're.
Right. Well, first, do you have any more questions of the witness?
I will if the court is allowing.
Well, we're doing a hearing, so if you have any more questions with regards to your objection to State's Exhibit 110, please ask them.
You would also agree that this statement, may I approach the witness?
Yes.
Thank you. Exhibit 110, you would agree that this was a statement that was made by you outside of court, right?
yes,
Okay, and so you weren't in this courtroom when you wrote all these things down.
no,
And in this, you make assertions about what happened with the crash. You made assertions about your observations that you made at the time. And you made assertions about the things that were told to you and the things that were said at the time. You would agree with that?
yes, based on evidence and statements, yes,
Based on the evidence and statements. And all those assertions that you made were assertions that were made outside of this court.
yes.
Your Honor, may I consult with plea counsel briefly? Your Honor, may I approach again?
Yes.
Thank you. Do you remember when you were at the scene, I guess, I want to talk about the purpose of why you got this warrant, that speed alone, you would agree that you have an understanding, and I think we even have it on the body cam. Speed alone is not sufficient to get a warrant. Judges wouldn't sign, or your belief is the judge wouldn't sign a warrant on speed alone. They would need other details like the details that you provided in this affidavit to get a warrant for the, the GPS and the other things that you're asking for.
Correct. That's why I was doing my investigation.
Understood. As to Exhibit 110, Your Honor, I'd have no further questions as to Exhibit 110.
State, any questions?
No, Your Honor.
All right, then the court will hear argument.
Yes, Your Honor. So as the court knows, an officer's search warrant is hearsay, and they are almost never admitted in front of a jury, and they're never admitted as an exhibit because the search warrant statements and assertions that are made are used for the truth of the matter asserted. And because they are out-of-court statements used for the truth of the matter asserted, it's hearsay and should be excluded on that basis. Additionally, whether or not there was probable cause to get the evidence is a law determination that is made by the court. It is not a fact determination that should be made by the jury. And so therefore, especially because we're in a punishment phase, there's not even a 3823 issue. So because of that, the more proper venue would be for the court to review the search warrant and review the evidence they're trying to get from that and make a legal ruling, as is the court's power and right and responsibility, and not have it go in front of the jury, which is not their, it is irrelevant for the jury to
Condescend to
know
the judge.
or
Good
understand
play.
about the
I like this.
specific statements and hearsay statements that are made in the warrant. Additionally, in this warrant itself, because the court has suppressed statements that are used to form the basis for probable cause, in this warrant, the fruit of the poisonous tree would dictate that that this warrant should not go in front, especially with those statements.
I got your poisonous tree
And
right here.
really, our argument will be, right now we're arguing just with the admission of the warrant, but then our argument will then move on to what the warrant obtained and why the warrant was faulty in that instance. And so that's why we're asking the court to sustain the objection to hearsay on Exhibit 110.
Jane, you ignorant slut.
All right, state.
Judge, in regards to the state's Exhibit 110, the court can make a determination looking at the search warrant itself, strike the parts that have been suppressed, and make a determination as to whether or not the search warrant was survived past scrutiny in that regard. Again, the state's Exhibit 110, the purpose of entering it is just so that the jury will be able to see that this information was obtained by a search warrant. The other information that was provided through the truck or obtained through the truck, that wasn't according to a search warrant, that was according to a consent to search. And so we just didn't want to we wanted to make sure that those two issues were not confused with one.
All right, and if I can see the search warrant, please. Oh, no, you can see. And is the plea ready on the other case? Yes. Excuse me, do you have a sticky? Thank you. All right. With regards to the search warrant, so that the record could be clear, the statements made by the defendant that the court granted the defense motions to suppress, and that would be the statement specifically to this officer only. And that statement that's in State's Exhibit 110 is the following. The suspect admitted to consuming alcohol prior to the crash, but claimed he only drank 4 beers and claimed he stopped drinking approximately 6 hours prior to the crash. The court is not considering that statement or any statements that were made by the defendant to this officer in making a determination on whether or not there was probable cause with regards to this search warrant. The court is, however, not suppressing any observations that this officer made. For example, in State's Exhibit 110, it states that this officer smelled an odor of intoxicants emitting from the suspect's breath. So defense, if you will refer, defense, do you have a copy of this?
Yes, sir.
All right. State, do you have a copy, or this is your only copy that I have?
Judge, I just exited out of Adobe I.
All right.
Sorry about that, Judge.
No problem.
Yes, Judge, I have it.
All right. So if you all will turn to page 2, defense, are you on page 2?
Yes, sir.
All right, the last paragraph on page 2, where it's states the suspect admitted. So the court is not considering that whatsoever. That is the only statement that the court sees where the defendant made a statement to this officer. Is there any other place, defense, that you see where it's alleged that your client made a statement to this officer?
Yes, Your Honor. If you look up above that, it's still at the beginning of that paragraph. I spoke with the suspect approximately 4 hours, and he was unclear about how the crash occurred. That
All right, and the court is not going to consider that as well.
understood.
All right, so the court will not consider that. Is there any other place that you all see in State's Exhibit 110 where your client is alleged to have made a statement?
Well, I guess it's just in her conclusory paragraph that she does on page 3. She includes his statements as part of that conclusory paragraph.
All right, what paragraph number is that on the last page, counsel?
Paragraph 2 on the page that has the signatures on it.
Okay.
And admitted to drinking prior to the crash.
All right, and the court will not consider the part where it states that he admitted to drinking prior to the crash?
Judge.
Yes.
Just on that point, there has come already testimony from one of the other officers that the defendant did admit to drinking alcohol.
No, I'm just dealing with specifically what's in this search warrant through this officer. So any statements that is alleged to have been made by Mr. Castro to this officer The court has already suppressed that. So with regard to that page, counsel, that part of the sentence where it states that your client admitted to drinking prior to the crash, the court is not considering that and making a determination of whether or not probable cause existed. Is there anything else from either side?
Only a clarification,
Yes.
if I may, that,
Of course, and you can remain seated.
okay, thank you, Judge.
I find that people hear better when everybody's seated.
Sure, just so that I'm clear on, as you know, to preserve the air, I have to make sure I'm making the right objections at the right time. So I believe what the court is doing is a probable cause analysis of the statements and the information left in the warrant or the PC affidavit.
Yes.
But we are not discussing whether or not this goes in front of the jury. We're just
No.
discussing this for the, okay, thank you, Judge.
Sure.
I have nothing further after that.
All right. So that the record is clear. In reviewing the affidavit for the search warrant on whether or not probable cause existed, the court is not considering statements made by Mr. Castro to this witness. The state previously granted the defense's motions to suppress statements that Mr. Castro made to this specific witness. So in reviewing the search warrant, state's exhibit number 110 and determining whether or not probable cause existed, the court is going to find that probable cause did exist with regards to the affidavit for search warrant, and that is excluding Mr. Castro's statements. Now that that is done, the next question is whether or not state's exhibit 110 should be admitted before the jury. Defense, what is your objection?
Yes, Your Honor, our objection is hearsay.
Oh, there won't be a civil trial. Those insurance carriers tender their limit so fast,
Not for the truth of
make
the
your
matter
head spin.
asserted, it's, again, it's to show that the search warrant was obtained lawfully and that it's not to conflate this with the earlier search of the truck.
Your Honor, if I may respond to that briefly.
Well, just a moment. Isn't she able to testify that she obtained a search warrant?
Yes, Judge.
So then state's exhibit number 110, is it needed to be admitted?
No, no.
All right. Thank you. Let's bring the jurors back in.
Your Honor, may I just, as far as, just for your timing, I believe that the next thing that they're going to do is try to offer the things that came in from that, and we would be requesting a 705 as to her expertise on those matters. If that, I don't want you to have to make them go in and out if you didn't want to, but we'll do whatever the court would like.
Well, we'll see what.
In a
is
civil
being
context, we're
asked
talking
for.
about
I have
negligence.
no idea
Yes, sir.
what's.
He
gonna
drove
be
into
asked for
a
from this
stationary vehicle
witness.
91 miles an hour.
All right, let's bring it in.
All right,
Al-
for the jury?
Alcohol doesn't even matter. It's negligent all day long. There's no doubt about it. So in a civil context, this is just a slam dunk. I might have handled a few cases. like
Everyone,
that.
please be seated. State, you may proceed.
So Sergeant Martinez, so you were able. Microphone. Oh. excuse me. So Sergeant
You
Martinez,
asked.
Were you able to obtain a search warrant in this case?
Yes.
And what were you in particular looking for?
I wanted to extract the Bosch multimedia module and also the LG OnStar module from the Chevrolet Silverado.
And you may have answered this before, but are you trained in how to pull that data from vehicles?
Yes, I'm a certified technician and analyst for those types of modules.
In a civil context, keep up with the class,
What type of
skeptical
training did you
chemist.
receive to be able to pull the data from these models?
I'll refer to my resume. So I received my Burla Vehicle System Forensics Technician and Examiner certification. That was back in March of 2022.
Can you explain to the jury what's Burla?
So Burla is the company that basically provided the
Oh,
training.
no.
They also provide the software and the hardware. in order
Now
to
Tyler's gonna take over
to
for Kim.
download those hard drives.
And what exactly would the program show if one were to download this data from?
I'm sorry, Tyler.
It's make and model dependent. For the most part, it shows
I will cut and
navigational
clip for
data,
you,
such
just the
as
way you like.
track logs.
In fact, I'm gonna talk
There'll
over
be,
her.
timestamps.
Respond to your dopey
Typically
comment.
with the multimedia modules, there's information as far as connected devices to the vehicle. Some makes and models will even give us transcripts of text messages that are sent and received, audio recordings. There's a lot of various information that we can get.
And is this training in the program that you were trained on, is this something that's widely used in just any type of police or investigatory field?
To my knowledge, it was becoming more and
Oh,
more popular
thank
at that
you.
time. So now I would imagine it's widely used. Yes.
I'm gonna approach with what's been marked as States Exhibit number 111. You recognize this?
Yes. So this is one of the track logs that I was able to retrieve from the LG OnStar module.
And what vehicle were you able to retrieve this from?
I love
This is from the Chevrolet Silverado.
And were you able to get any more information from the truck that verified or at least matched up with the information you see here?
Yes. So these these timestamps coincided with map. So
Your Honor,
whenever
I
you
just
open,
object to her testifying from a document not in evidence.
All right.
Hearsay.
Sustained to hearsay.
Well, is this a true and accurate copy of the information that you obtained from the defendant's truck?
yes.
Your Honor, state would offer States Exhibit number 111.
Your Honor, we would object to speculation as to this witness's ability to extract it and request a 705 hearing as to her expertise.
All right, ladies and gentlemen, I'm going to have you wait in the back of the jury room. And I will probably bring you back no later than 3:15. All right, everyone, please rise for the jurors.
Oh, sweet Jesus. What?
Yes.
All right, everyone, please be seated. Mr. Chumley
Yes.
and Mr. Shaughnessy,
Yes, ma'am.
I will take you all up after we finish with this hearing outside the presence of the jury.
Thanks, super, Your Honor. Thank
All
you.
right, thank you. All right, defense.
Yes, Your Honor.
They are gonna spend another night
May
in
I
a
start by-
hotel.
Well, here, I'll ask this question first. Sergeant
Your monthly
Martinez, I noticed that you've
free
been
breakfast.
looking at, I guess, some documents that you have as far as reminding yourself, I believe, of your trainings and your burglar training or whatever else is that. Do you have documents up there like that?
It's my resume.
Yes, and Your Honor, under the rules, I just asked that I be allowed to look at a copy of that.
Sure. Could you let defense counsel see your CV, please?
Number one, know what I'm saying? Number one, know what I'm saying? We are the Lord talk with my crew. Number one,
Yes.
All right, is there an extra microphone?
Oh, that.
Excuse me. Here you are. So you all won't have to be switching back and forth here.
Thank you.
You're welcome. Thank you. Yes.
Your Honor, may I approach and give her? this
Yes.
back? Thank you. Sergeant Martinez, in particular, I think you referenced this as the LG OnStar module.
Yes.
And as far as the LG OnStar module, did you have any information that that the GPS track logs that were recovered, was that track logs that the defendant was inputting into the system, or was this being tracked without, I guess, without his input, if you know.
So that's not something that the module specified. It basically just gave me the time-stamped track logs.
So you are unaware if this module was tracking the defendant without his knowledge that he was being tracked?
It's a system that basically just pinpoints GPS points as you're driving.
Sure. And I guess the question I have is, you were unaware though that you don't know if this was tracking him without his consent or without his knowledge that he was being tracked. You don't know if that was the case or not.
I'm not sure if he was inputting the navigation or if it just recording navigation.
And are you aware if this system has any ability for somebody to opt out of being tracked at all times without their knowledge?
Usually OnStar is a service that you have to subscribe to. But as far as the module storing data, I'm not sure if it requires a subscription in order to record the data.
Okay, but did you check or did you ask to see if he did subscribe to OnStar, the defendant?
No, I didn't check with OnStar.
Okay, so as far as you know, the OnStar could have been tracking him without his knowledge when he was going to these different locations that you pulled out of the module.
I imagine that's possible, yes.
And you understand that, for instance, if I put a tracker on somebody's vehicle without their knowledge, that could be a crime.
If a person does it, yes, yeah.
If a person or a company puts a tracker on somebody's vehicle without their knowledge, it could be a crime if they're not giving the person notice that they're tracking. Is that, you agree with that?
Okay.
Because you know that people have been arrested for putting unauthorized trackers on other people's vehicles.
Yes, like stalkers.
Like stalkers, right. And so as far as in this particular, just so it's clear for the record in the court, because the court hasn't seen this, Exhibit 111 that you were referring to basically is a page that gives you addresses that you're saying that the defendant's vehicle went to that evening before the crash.
I believe that one just has a date and timestamps and distances covered. I don't believe it details any addresses.
Okay. And did you, or was it your intent to provide testimony to the court and to this jury that you could tell which addresses that the defendant went to?
Not specific addresses. It gives locations. Typically, I can pinpoint it down to like roadways traveled, intersections, things like that.
Right. And would that be on a different document than State's Exhibit 111? I'm sorry, you need to see it.
It's not on that document.
Yes, you can approach.
Okay. I think we got the answer. So the information you're talking about, is it your intent? Because I don't know. Is it your intent to testify about specific locations that you believe that the defendant went to?
If that's the questions that they're going to ask me, yes, I can.
Okay. So as far as Exhibit 111, is it your intent to testify that you extracted data from the vehicle that you were trained to extract from the OnStar, let me get it right, the LG OnStar module? And your intent is to say that you believe that the vehicle drove this many miles?
Based on the track logs, yes.
Right. You do not know who is driving the vehicle though, based upon the information.
At those specified, not at all of those specified times, but the times go up until the time of the crash.
Which you do know he was driving at the time.
Correct.
But not before.
Not prior to, no, sir.
And do you remember discussing with Agent Peterson that your OnStar data that you recovered had time gaps of missing data?
I believe, yes, there was some time that was unaccounted for.
And because I know you've been trained to extract, but you have not been trained in the actual workings of how the OnStar module works as far as being able to diagnose why there was missing data or if it was working properly.
It appeared to be working properly. There weren't any errors that I received. Missing data, there's a lot of explanations for that, especially when it comes to GPS data.
Okay, sure. But I guess the idea is that you cannot say what the purpose or what, I mean, I guess what the reason is for the missing data in this case on this car that you extracted the data.
I can say that it did not appear to be a malfunction.
But you cannot say why there was missing data.
Correct.
And if we thought about like how long, it was almost, you would say almost a 2-hour time gap of missing data.
From the track logs, yes.
From about 8:10 on the evening before the crash, on the date before the crash to 9:57.
I'd have to see the track log.
Yes. One more. What number? Your Honor, may I first witness with the exhibit?
Yes.
I don't know the number and don't have a sticker, but I would ask to mark it next in order if the court does know what the next number is.
All right, is it a defense exhibit?
It's a defense exhibit. Yes.
All right, for purposes of this hearing, you want to mark it as 3 with a letter? All right, defense? Ms. O'Hagan,
Yes.
3A?
3A. Okay, Judge.
Currently, and Carlos. I may approach with.
Yes.
Approaching with what I've marked as Exhibit 3A for the purposes of this hearing. Does this look like the email that you and Agent Peterson sent back and forth to each other?
It appears to be yes.
And I guess if you can look at the top part of that, does that help refresh your memory as to the times of the gap that you observed in the data?
Yes, I notated the time gap from the track log. And later we were able to fill in the majority of that time.
Okay, and was that time, as I said, 8:10 to 9:57?
Yes.
Normal.
Well, I guess so. Is it on? I'll do it on now. Okay. Your Honor, as to 111, this is all that I have. I do understand that they plan on offering the location data. And so I guess having the jury go in and out, and it looks like I'm the one that's making them keep getting up and going in and out, I would prefer, if the court is amenable to it, for us to just get all of this out right now while the jury's out, so we can have this hearing and the court can make the ruling on all.
Do you have any more questions about location data?
I do not have any more questions about 111, but they're going to offer 112, I believe, that's going to show specific locations.
All right, with regards to 111, the court will hear argument.
Yes, Your Honor. So I guess first and foremost, our objection that we are going to make is under 3823 of the Texas Code of Criminal Procedure. The state cannot show that this data was not collected in violation of a law of the state of Texas, as 3823 states, that it can be a police officer or any other person. Person has been defined as corporation in the code. So a corporation can be considered a person for those, like a corporate person. And what we would say is that OnStar has collected data unbeknownst to a person, to the defendant, which is in violation of 3823. I understand under the Fourth Amendment that law has been interpreted that it is only state actors. However, in the state of Texas, if there is a violation of state law by any means or any person, then that can and should be excluded. So we're asking
So
for.
are you arguing that OnStar's collection of data is illegal?
I'm arguing that OnStar's collection of data without there being any proof that the person was notified that they were collecting data. Because in this case, if he had signed up for OnStar, I can understand that. But what the witness testified to is that they are collecting data even when somebody hasn't signed up. Or they could be collecting data even when a person has not signed up for the
You gotta be
service.
kidding me.
If you sign up for the service, you have to check off the terms of service. But if you have not signed up for that service, then they are collecting data without the person's consent or knowledge. And that is a crime in the state of Texas.
So you're arguing that OnStar is giving free services to everyone?
My understanding is that this is not the defendant was not using OnStar, and OnStar was surreptitiously tracking the defendant without his knowledge. He was not using their service. They have not provided any evidence that he was using their service, and I believe that he was not. The issue with that is that I think many people would be surprised to know that OnStar is tracking you even if you haven't signed up for their service. And that is what the witness testified to.
Nobody's
that
surprised
these
to know that.
modules will be tracking the person even if they have not signed up, which would be a violation under 3823, and this evidence should be excluded because of that.
All right, State.
Your Honor, there's been no evidence that OnStar collected this information through a violation of the law of the state of Texas. At this point, it's speculation that the law was violated. There's been no evidence that the defendant didn't know or that had no knowledge or anything of that sort. So we'd ask that the evidence be let in.
All right.
I do have-
Defense, I'll give you your final argument.
I have further argument just as to the veracity of this particular
sure you
data,
do.
moving past the 3823 argument. The witness did testify that there is an unexplained gap in the GPS and in the location services. That unexplained gap cannot accurately be explained by this witness. And so we would argue that this witness does not have the sufficient technical knowledge to be able to explain to the jury what it is. And finally, evidence of where he has gone at the, on the evening, and I guess at the time in question, is not relevant, and under 403, it should be excluded as well.
All right. The objection by defense is overruled. The court is performing a 404-3 balancing test. The court is going to find that it's more probative than prejudicial. Let's move on to the next issue. Is there something else that counsel that you find objectionable that the witness will be testifying to?
In conversations with the state, they have told me that they intend to offer the actual locations where the defendant was, and I would like to be able to 705 this officer on that particular issue.
All right, you may proceed.
Sergeant, I think that one of the things you testified to is that in addition to getting, I guess, the times of driving, even though you don't know if it were him driving, that you also you pinpointed some possible or potential locations. Am I right about that?
Yes, sir.
Okay. And the locations meaning like locations where he was or where you believe that the car was.
Where the vehicle was driving and parked.
Your Honor, I'm sorry, may I approach and retrieve defendants 3A?
Yes.
Oh, I'm sorry, I gave it to them. In that situation, what you were able to testify to is that you cannot say exactly where a person is. You can just say they are in the general area or the general location of a place. You would agree with that?
Based on the data that I had, yes.
Right, because a person, if there are two shops next to each other and one shop is a dress shop and one shop is a suit shop, you wouldn't know which one that they were actually located at.
I was able to determine where the defendant was at a later time with other evidence.
With other evidence, but not with the evidence here.
Not solely with my evidence. I placed him in a general vicinity or at a location. Yeah, if there were multiple shops or bars or restaurants at that location, then I wasn't able to pinpoint the exact location solely with my information.
Sure. And so what you did is you had to rely on out-of-court statements from somebody else, namely Agent Peterson, who went to those locations. Is that correct?
Correct. TABC agent Peterson worked in assisting as far as getting further evidence.
And so TABC agent Peterson is the one that told you that I believe he was located here based on other evidence that's not included in what you were able to gather from the GPS data.
Correct. He provided sales receipts.
So you had sales receipts that were provided. Notably, though, there were no sales receipts in specific to the Hills and Dales establishment that that you believe that the defendant was located at hours before the crash.
Nothing, to my recollection, nothing was obtained from Hills and Dales.
Okay, so what you're testifying to really is that for that location and others based solely on the GPS data, you could not testify to where the defendant's car was located without having that other information or without having those out-of-court statements from Agent Peterson that he made to you at the time of your investigation.
I could testify to where the vehicle was at the times from the track logs.
I guess when we say was, I'd like to be specific. You can testify to a general location, but you cannot testify to where it actually was solely based on these logs.
No, I can say where the vehicle was. If you're asking if I can say where your client was, then no.
Well, I guess what I mean is that even in where the vehicle was, there are different locations that the vehicle could have actually been located at. It doesn't go within like an inch. It goes within an area, a generalized location area that is, I guess, that is more than just the exact location.
They're within feet. The GPS track logs are within feet. So whenever the GPS is tracking it on the roadway, like on a specific roadway, I can say with absolute certainty that the vehicle's on that roadway.
That the vehicle is on that roadway, but not exactly where it is on that roadway.
Within feet.
Well, you're saying within feet. So sometimes you can tell within feet, but as you know from your training, with GPS locations, just like you don't know sometimes why there's a gap in the data, sometimes GPS location can be off by more than feet.
It's tracked within seconds, so it's doing a constant track log. That's the point of the track log. So it's not pinpointing a specific spot just at this time. It's doing it in a log. So every few seconds it's tracking, and that's why it shows up as a log, as a route per se.
Sure. But I guess what I'm saying is that if a car or a vehicle that is being tracked is stationary, then it is stationary. But there are sometimes you can tell within a few feet, and there's sometimes that the distance is actually further based upon GPS technology.
Yeah, not a substantial amount of difference in distance.
So you would say that if you testified, you could only say that a car was at a location. You could not say that the defendant was at any location based upon this.
Based solely on that information, no.
Your Honor, pass the witness.
State.
Nothing from the state here.
All right, court will hear argument.
Yes, Your Honor. We would renew our 3823 argument. I understand the court has overruled it, but we do have to keep asserting it. And so I guess may I assume that the court is also overruling me on the 3823 issue?
Well, I'll hear your argument.
Yes, Your Honor. So the same 3823 issue that he is being tracked, they have not shown, and nor did the witness even try to get any information that he had actually signed up for this service or that any of this was consensual or with the defendant's knowledge. But moving to the specifics of the location, this witness would have to rely on statements that are made to her, hearsay statements that were made by an out-of-court witness, used to prove the truth of the matter asserted, to wit, that the defendant was actually located in a specific place.
All right, and this out-of-court witness that you're speaking of, would that be an officer and a part of the investigation?
It would be a TABC officer, and it would not be a part of the investigation. The case law is pretty clear that the idea that information acted on, which is commonly used, can be used to explain why an officer went to a particular location or went to a particular place, but it cannot be used to show the truth of the matter asserted. And in this case, a very testimonial statement, which is from Agent Peterson, which is the defendant was located in this bar at this time. And so that's ultimately what we believe the state is trying to do, is say the defendant went from bar to bar to bar But this witness cannot testify to that because she would have to use an out-of-court statement that is a testimonial statement that goes way past the information acted on exception or exemption to the hearsay rule. And so as far as this witness being able to do that, she does not have the sufficient information to be able to say that the defendant was in any of these places. And then because of that, showing that a vehicle was located becomes the probative value of that without being able to say that the defendant was actually there. The probative value of that becomes way less, and the prejudicial danger of that becomes way more. And so now we have under 403 additionally, that if she is allowed, based upon hearsay, to say that the defendant was drinking at a bar, which is what we ultimately think that that's the purpose of this testimony, then she is being able to get that from hearsay and other things that do not qualify under hearsay exception.
Thank you. So the court is doing a 403 balancing test. The court is going to find that it's more probative than prejudicial. State, with regards to this witness, based upon what I've heard in this hearing, this witness cannot definitively say that the defendant was at a specific location or inside a location. So the defendant will not be allowed to testify that the defendant was at a specific location. However, if this witness is planning to testify, and I have no idea what she's planning to testify to, if she's planning to testify, for example, that the defendant was at location A, and at location A, just hypothetically, is Target, Walmart, HEB, then this witness can testify. Defendant was at the vehicle was at location A, and there's Target, there's Walmart, there's HEB in that vicinity. And then defense, you'll have to cross-examine. Is there anything else? All right, and
For
if
the
I could
defense,
have parties,
I'm sorry, briefly, and I understand.
and if you'll give 2 to the state as well. And there's something else you wanted to add to the record, counsel?
Yes, Your Honor, just so I can make clear, going back to the 3823, may I assume the court's overruled that
Yes.
objection? Thank you. And then may I have a running objection to all of these objections that I've made as to her testimony so that I don't keep having to stand up and object while she is testifying, only to the specific things that we've discussed here in the hearing.
You can make whatever objections you wish to make, counsel.
I understand. So, and I know it's within the court's discretion to give me a running objection. Is the court denying the running objection?
You can make whatever objection you wish to make, counsel.
Yes, Your Honor.
All right, so any other questions? All right, so off the record, I've just given you all the copy of what you requested from the charge. So those are the 2 pages. Those will be the last 2 pages. So it's page 5 and 6. So if you'll just remove the current pages and defense, that's adding the bias or prejudice that you wanted added. And then I'm going to take this plea up, counsels. We'll take the plea up, and then after I take this plea up, we will bring the jury in. All right,
Go to law
court is
school, they
calling
said.
2022 CR 7550.
It'll be fun, they said.
State of Texas versus Jasmine Hardaway. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Ed Shaughnessy.
All right, and are you Miss Hardaway? All right, counsel, have you received all of the discovery in this case, and did you review it with your client? Court will find that the state is in compliance with discovery. Ms. Hardaway, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it? You need to speak up.
Yeah.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, you're not, Your Honor. Waiving count 2, proceeding on count 1 alone with the lesser included offense of assault bodily injury, Class A misdemeanor.
Any objection?
None.
Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand that the state is proceeding on the lesser included offense in count 1 of assault bodily injury as a Class A misdemeanor? Range of punishment is up to 1 year in the Bear County Jail and up to a $4,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Yes, ma'am. Did you understand by entering this plea, you are giving up those rights? Yes, ma'am. And did you intend to give up those rights and enter into a plea in this case? All right, off the record for a moment.
I don't know if you want to start with me today. Kind of in a mood, Stacy. Seriously, Stacy, I've got some questions for you. Does your mom have it going on? Let's start with that. We love you. We do. We do. I know, Debbie. That's why I've been getting younger. Do you want me to reenact this conversation for you? Okay. Okay. Here's Judge Boyd. You need to do better. Be a more responsible person. Here's the defendant. Okay, you old bag. I'll pretend for the next 30 seconds. Thank you. Yeah, I guess that would be the appropriate response. I did like his OnStar argument. You know, it was a full hamster. Let me find my hamster. Do you know that OnStar is tracking you? Do you know that McDonald's is telling you food? Do you know that we don't care? Okay, I'm better now. witness. I really don't know if you want to go there. I really don't. I like how the latecomers have no idea what they're walking into.
Oh man, I gotta get together.
Trial. This is crazy. Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore? I never want to hear it again. Sweet Jesus. You're not a whore? Not a whore? You're not a whore? I never want to hear it again. It gets worse.
There were drugs involved that were given to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack.
Let's go. You didn't say the cat jumped on his wiener, did you? Sit down and shut up. Shut up. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up.
Can you just let this go for once? For once? Once?
Okay, bad doing no. Mr. Sharps. Not a whore. Mr. Sharps. Mr. Sharps. Mr. Sharps.
And what?
Everybody fucking dance. You're not a whore. You're not a whore. I never want to hear it again. You're not a whore. You're not a whore. I never want to hear it.
So, taking a look at state exhibits number 112 through 120, what exactly were you looking at?
So these were the maps that correspond with the track log points in the Burles system, the software system.
And what exactly do these points show?
So they're GPS tracked points, and they show basically a route that the vehicle took from a starting to a stopping point.
And points that are in the maps, do they correspond to the track log that that's contained in State's Exhibit number 111?
Yes.
And are these true and accurate depictions of the track logs that you saw?
Yes.
Have they been altered in any way?
No.
Your Honor, State would offer State Exhibit numbers 112 through 120 tender to defense.
And Your Honor, we just would stand on our previous objections.
All right, and could I see States Exhibits 112 through 120, please? All right, defense, your objection is no, it will be overruled. States Exhibits 112 through 120 is admitted.
Permission to publish, Judge.
Granted.
I'm showing you what's been on State Exhibit number 112. What are we looking at here?
So this is a map of one of the track logs. And to my recollection, the starting point would be this initial blue dot that's on the far right of the paper on 1604. And the vehicle is tracked down 1604 to 281 through a turnaround and then through local roadways to an endpoint. I believe it was like 15,800. I wrote it in my report. 13,800 Jones Maltzberger Road.
And Sergeant Martinez, if you'd like to step down from the well, so you can kind of point towards the exhibit. So the
Okay.
jury can see. Provide you with pencil. So what exactly were you talking about earlier? Where was the starting point?
So from the track log data, the starting point was this initial point on 1604. And each of these dots correspond to a date and time stamped in the system.
And looking at State's Exhibit number 111, what time was this route started?
So this would have been the initial point that was reported at 6:02 p.m. local time on July 21st, 2022.
And when did that end?
That track log was through 6:20 p.m. on July 21st, 2022.
And I'm showing what's been marked as State's Exhibit number 113. What is this?
So these are, it looks like a zoomed in view of multiple track log points, within a time frame. Like I said, the GPS points are tracked every few seconds. So multiple points at the same location. And that's where the track log ends, indicating that the vehicle was parked and stopped.
And is that the end point for what was seen in State's Exhibit number 112?
Correct.
And are you familiar, what's in that area where the defendant parked?
So I am familiar with this area. In the immediate area, there's a Bushwood Country Club, which is, to my knowledge, is a golf driving range. And there's also a Pups and Pals bar and grill.
And what's the next time that shows up on the defendant's vehicle's track log?
Looks like 7:57 p.m. on July 21st, 2022.
And what's the end time on that time?
Your Honor, briefly, just may I assume that the objections that I've made to these also include the testimony that she has about those?
Yes, your objections are noted and overruled.
Yes, Your Honor. Thank you.
You're welcome.
And so what time was that end point?
That track log ended at 8:10 p.m. on July 21st, 2022.
And I'm showing you what's been marked as State's Exhibit number 114. What is the jury taking a look at here?
So this is that track log. The starting point is going to be at the end point from the previous track log, that 13,800 Jones Maltzberger Road. And the vehicle is basically tracked down local roads to this end point on the far right side of the paper, which is Judson Road and Stall Road.
And are you familiar, what's in that area?
To my knowledge, in that area, there's a Lefty's Draft House. There's a pizzeria. There's also like a fruteria. There's a Fisher's Market, which is a corner store, a convenience store. Church's Chicken. It's basically a shopping center of bars and restaurants.
And so looking at State's Exhibit number 111, what's the third place that you, or what's the third time that you start or begin to start tracking the defendant's vehicle?
The third track log shows up at 9:57 p.m. on July 21st, 2022, and it goes through 10:01 p.m. on July 21st, 2022.
And I'm showing you what's been marked already as State's Exhibit number 115. What is this photograph of?
So these are the track points of that track log. The vehicle driving around this is the La Cantera, the Rim Shopping Center.
And are you familiar, what's in that area?
So the businesses that were in the immediate area of these track log points were basically the Rock and Rye Bar, Four Cheese Tacos, there's the Rustic. It's mainly just a large area of bars and restaurants.
Okay, and were there any other places that were open at that time, or were there any other stores that were open at that time?
To my knowledge, at that
Your Honor, I'll
time.
object to speculation, and I'd like to take the witness on board on.
All right, you may take the witness on board here.
Yes. So Sergeant Martinez, just briefly, did you go and make that scene on the night that we're talking about to see which stores were open and which were not?
I did not go out. Oh, you're talking about the evening of the crash?
Right, well, this is detailing. I think the question to you was, what stores were open at this time on this date? Because you're detailing a specific time and date on this States Exhibit 115.
On July 21st at approximately 10 p.m., I was at work, so I was not at the Lock and Terror and Shopping Center.
I understand. And so on that date at that time, you don't have any independent knowledge of what stores were open and what stores were not.
My knowledge will be based on store published hours, sir.
Right. And so you would not know if these stores were actually open or they weren't. Would you agree with that?
Correct.
Okay. Your Honor, we would just object to that as speculation.
All right, objection is overruled. You may proceed.
Answer the question.
So to my knowledge, none of the shopping stores were open, just the bars and restaurants.
And what's that? There's a fourth time that you track defendant's vehicle. What time does that begin?
So that begins at 10:57 p.m. on July 21st, 2022.
Okay, and what time does that tracking end?
Begins at 11:10 p.m. on July 21st, still 2022.
I'm showing you what's been marked as States Exhibit number 116. What are we looking at here?
So that the track log begins where it ended from the previous track log, which is at the Rim Shopping Center. The vehicle drives through the Rim Shopping Center to get out to the local road to Lock and Terror Parkway. Proceeds southbound on the access road, then entering the highway to get on the to travel southbound to get on the 1604 loop traveling westbound.
And I'm showing you what's been marked as States Exhibit number 117. Do you recognize this?
Yes, this is the zoomed in point of the final track logs from the track log we were just referring to.
And Sergeant Martinez, what is in that area? Are you familiar with the general area?
Yes, in the immediate area, it's Hills and Dales Ice House.
Are there any other stores, restaurants, anything else open in that area?
The only other restaurant that, like I said, that's in the immediate area is a taqueria.
Okay. And going back to that track log in States Exhibit number 111, what's the next time that we pick up the defendant's vehicle?
The next timestamp for the track log is 2:02 a.m. on now 7/22/2022.
So, okay, so it starts at 2 a.m., is that correct?
Correct.
And at what time does it end?
It ends at 2:21 a.m. on 7/22/2022.
Showing you what's been marked as States Exhibit number 118. What exactly are we looking at here?
So this is the track points for that log, and it starts out at on the left side of the sheet, which is where Hills and Dales Ice House was located. The vehicle has to travel slightly westbound on 1604 to take a turnaround to proceed eastbound on 1604. The track log points track the vehicle traveling eastbound on 1604 all the way to 281 north to the end point here, this final dot most north on the page to the approximate area of the crash.
And I'm showing you what's been marked as States Exhibit number 119. What are we looking at here?
So that's the zoomed in view of the final track points for that track log we were just referring to. And it tracked the vehicle just north of Evans Road on Fleet.
And is that close to where the crash that happened on July 22nd of 2022?
That is the immediate area of where the crash occurred.
Okay, and so just curious, what closes normally at around 2 a.m.?
In my experience as a crash investigator, bars.
You can have a seat now. Thank you. Well, just for the record, the state's going to re-offer States Exhibit number 119. Re-offer that.
All right, and any objections to the redacted 109?
If I remember correctly, that is, I did make objections to the fact that the transcript was not a certified transcript. If that is part of the new 109, and so I would renew that objection, but no further.
All right, objection is overruled. The redacted 109 is admitted.
I'm going to show you States 109.
Oh my God.
Just to clear up a few things.
Hallelujah.
I'm going to ask, and I'm going to point towards the paper because that may be the easiest way. Well, what was the question here? Can you read from this point?
Question shows, what was the purpose of your travel? Where were you going?
And what was the answer?
Answer shows, I I was actually just with a friend, and then I was on my way home.
Okay, and again, you're familiar with where the defendant lives?
Yes, sir. At the time of the crash, he resided in Shirts.
I don't care.
And so looking at
109's
the
been
vehicle
admitted.
track log, it appears
Oh my gosh, it is a double rainbow. I cannot believe it. It's a freaking double rainbow.
Going eastbound on 1604 and then northbound on 281.
And so if that vehicle was going to travel to the defendant's home, what road or highway would it have had to have taken? Are you aware?
He should have continued on
I don't know what
1604
109
eastbound all the way
contains.
to 35
I'm
north.
excited.
But instead, again, it turned north on 281.
Correct.
And then I'm going to point to here. Can you read that question and answer?
Question shows traffic heavy, stop and go, or maybe light.
What was the answer?
Answer, it was actually kind of light.
Okay, and then from here, can you continue reading?
Question shows, where did this take place? What's the name of the road, or where did it happen? Or where did that happen? Excuse me.
And what about the answer? And you can continue reading up until, I'd say about this point. Well, right up until there, where my finger is. And you can continue reading.
Stop here.
Yeah.
Shows answer, it was on Highway 281, northbound. Question, and what's a nearby crossroad or nearby intersection? Answer, Evans Road. Question, okay, this part of 281, does it have 3 lanes each way or is it more or less? Answer, it's new construction, but it is, yeah, I believe it's 3 lanes. Question, and what's that speed limit there? Is it 55 or 65? Answer, I believe it's 65. Sick.
Okay.
Are they staying at a Hampton Inn or a Holiday Inn Express
Can you
tonight?
start here. Can you start with reading that question?
Question, so if you could walk me through, tell me what happened. Answer, so I really don't remember a lot of the accident. It was a very bad accident. I know that my truck had flipped over and I know that there were multiple vehicles involved. But as far as like putting things together, I really can't. Like all I see in my head is just like, and it's almost like a movie, like pauses, but everything just kind of exploded and was flying around in my truck.
And then continuing on to the next page.
Question, wow. Answer, yeah, it was like really still shaken up about it. Like this was pauses inaudible. I mean, you only see accidents like this in movies. Like
Then again, continue reading, please.
question, answer, car crashings and stuff like that. Question, yeah. Answer, it's really wild. I don't remember if the other car actually got into the side of me, and that's what flipped me over. But looking at my truck, there's damage from both sides and the front end. So I mean,
Well, that
size
jury did
and
this to themselves.
the way my arms and my ribs feel, like
They
I
deserve
feel
every
like
gripping
they
moment.
were just flying around everywhere. Like I was thrown around like a rag doll, just kind of like pauses, another voice audible, being held in by my seatbelt. I mean, I'm very lucky to be alive and like walk away from this. But it just like pauses mentally. I can't process or put anything together.
Flipping to page 7. So I'm going to ask that you read from here.
Question, you had just left with your friend? Answer, yeah.
And continue.
Question, okay. Answer, no, I just went to see him for a little while. I didn't, yeah.
Question. From right here, can you continue reading?
Yes. Question. So I hate to continue to ask these types of questions. This is going to get a little sensitive. But as far as the number of vehicles that were involved, do you think, do you think it was more than 3? Answer. There was 4 vehicles involved. One of them was a 18-wheeler.
And if you can continue.
I hope those tasteless eggs
Until this point.
and watered down coffee were worth it
This is
for them.
shows answer, and I think that's the one thing that I remember hitting, because I guess I was sliding, and then when the truck flipped back over, I believe that the 18-wheeler is what stopped me. Question. Okay, and then what time of day was this? Answer. It was early in the morning. I want to say it was around 1:30 or 2 o'clock in the morning.
Defense?
Yes, Your Honor, thank you. So Sergeant Martinez, I guess the first thing is when you said that you testified that Alex lived in Shirts. Is that right?
Yes.
Okay, but did you get that off of a driver's license or something like that?
Off of his driver's license and also confirming with him.
Okay, but did you realize that at the time his parents lived in Garden Ridge?
I did not.
Okay, but if they did, then that would be a little bit more understandable if he were going to that home.
To my knowledge, Garden Ridge is also located up 35 North.
Well, you can go 46 to 309, 3009,
Okay.
right? I mean, you could from there. That's all I'm saying. Because I guess sometimes, as you know, people have an address, I guess, that's established, and sometimes they live with relatives or somebody else, and that's kind of their day-to-day living.
Like I said, for the purposes of my investigation, I confirmed with him that the information on his driver's license were true and accurate, and that's where he resided.
Right. And so I guess what I mean is, and I'm kind of talking about just a little bit, my question is a little bit different. It's, yes, we can reside at an address, but for one reason or another, we can also stay at a different address, like with other family members for, like I said, one reason or another.
Okay.
Would that be, you understand that?
If you're asking me if he was staying with his relatives, I have no idea, sir.
Right. And I guess that's my point. I mean, I just want to make sure that that everybody's clear that when you testify that he was living there, that doesn't necessarily mean that he was living there every day.
Okay.
Right. Okay. So, as far as these different, you went through with the jury, these different locations. One of the things that I think you're clear about is you're not saying that Alex was at any of these locations with that testimony based upon those documents, right?
Based strictly on the evidence from the track logs, I was stating where the vehicle was located.
Right. And you can't, based on that testimony or based on that evidence from the track logs, you cannot state where he was.
Based solely on that evidence, no, I'm not able to say where he was.
Okay. And so as far as, in some of these places, were there any like apartment complexes or residential kind of areas and streets that were around these places that you talked about?
Around, but not in the immediate area.
How
Okay, so
how
that
many
there
times
were
are we going to
around
do
in
this?
different places that you talked about.
Yes.
All right. And I think what you read there was that he had said he was with a friend, and then he left that friend and he was driving. I guess what he said in that transcript you were reading, he was driving home.
Yes.
Judge, I'll pass with this.
Any further question?
Nothing from the state.
Is this witness excused or subject for recall?
We're fine, excuse me.
Excuse from the state judge.
All right, the rule has been invoked. You're still not allowed to discuss your testimony with anyone until this case is concluded.
Yes, ma'am.
All right, you may step down. State, call your next witness.
Yes, Your Honor, the state called.
Oh my gosh, it is a double rainbow. I cannot believe it. It's a freaking double rainbow.
That was just an easy starter witness. Now
If
things
you'll
get
raise your
tough.
right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. If you'll have a seat, make sure you keep your voice up so that the members of the jury can hear. And if you'll state your name for the record.
Barbara Cheryl West.
State.
Thank you, Your Honor. Ms. West, can you please just introduce yourself to the jury?
I am Barbara West. My daughter is Alexandra Shea West Seibert.
You're showing on screen here, the state exhibit number 78. My accurate saying that this was your daughter.
That was my daughter.
In fact, this picture was taken literally maybe a couple of months before she.
It was
Okay.
taken, that picture.
Now we're
was
going from
actually
boring to
taken,
horrific.
About a month and a half or 2 months by her best
You're
friend.
welcome.
Alex wasn't really a photography person, so she had her best friend who liked to take pictures, take her graduation photos. She did it covertly. She didn't want anybody to know she had them taken. So she and her friend went to UTSA, the grounds, and had them taken. Yes.
In fact, when did you receive these photos?
Shortly before Alexandra had died, she had just ordered some announcements for her graduation. And her friend Liz said, "Did Alex let you see all the photos that we took?" And I said, "Nope, she did not." And so she said, "Let me send them all to you." And so she sent me a lot of these photos. Alex used that one for her. I think we just received the card package for her graduation announcements, and she really was very shy, so she didn't know who to give them to. And I had them in an envelope and found all of those announcements.
Those announcements. Well, can you just, I know I said briefly, but I know that you had a lifetime with her of
I did.
24 years. Can you just describe Alex to the jury?
I can. So Alex is my baby. I have 2 older children, and Alex is my husband's only baby, only child. So she was his everything. And they were partners in crime. I'm going to tell you that right now. From the time she was little, she was able to spend on the summers, he builds homes. So she would walk the houses with him, and she had a little pink hard hat. And so he would show her how to mark the studs and bowed studs and different things. So she just thought her dad was everything. And as she got older, that really didn't change. He would take her to breakfast until she was in, I guess it was right before she got into middle school. Every day he would have breakfast with her. So it was a big deal for her to have her dad there. So she would do that with him. And I was fine with it because I had other things to do. So she liked that time with her dad. And then as she got a little bit older, they started going to the grocery store together. We used to go all together as a family, but they started avoiding me in the aisles. So I would then decided I would just buy my own groceries and not have them make fun of me in the grocery store. So it was her dad and Alex all the time. Thursday mornings, she was off on Thursday mornings. I think Josh had attested to that was her day off. And so she and her dad, she would never do anything else with any other friends. Thursday
They
morning
could.
was, I have to go to the grocery store
Except
with my
they're
dad. So it's
part of the
been
problem.
very challenging because even going to the grocery store now, my husband is having a very difficult time. He would walk the aisles and say, "Well, Alex would pick that up," or he would see something and he'd say, "Well, we need to get that for Alex because she loves certain things." So I would say, I always go, "Yep." And so we'll buy it. It'll sit around for a while at the house because nobody but Alex would eat some of that. I'm going to be honest with you, but those were things that Alex did. He bought her, or he finally caved, and she has a dog. It's not really a normal sized dog. It's a Great Dane. And Alex and her oh, yes.
For a second.
Yes. Oh, the picture.
I just want to show you this picture. You're speaking about a dog.
Yes,
And the reason I want to ask you, if you recognize state exhibit number 121,
yes, I do. That is Alex, and blue, it's a selfie we found
selfie that you
Mhm.
found after her death.
after her death. Yes,
And this is the dog you're speaking of that her father bought her,
yes.
your husband, and that
Oh,
she
this
adored
is-
that dog. Is that right?
It is a sad statement. Yes, she adored that dog.
This
She
is
slept with
rough.
that dog anywhere that dog ended up. If it was, he had to be in his crate, she was in the crate with him. If it was in her bedroom, it was in her bedroom with him. So it was one of those interesting deals.
In fact, that night that she passed, she was coming home
For the dog.
for the dog.
She would, I mean, I would always say, what about Blue needs me? Josh is fine. And I was like, that's fine. That's okay.
You're out at this time. Senator Defense for entering into evidence, state exhibit number 121.
No objections, Judge. All right, state exhibit 121 is admitted without objection.
Any approach to the jury, Your Honor?
Yes.
Yes.
That's a big dog.
He's a large dog. He's a very large dog. He is, at the time Alex, was killed, he weighed, I'd say Blue was still what I'd call a puppy because Great Danes grow until they're, about 3. So Blue was about 2, a little shy of 3, and he weighed about 155 pounds. So he was a large puppy, I will tell you that. And so, yes, Alex always would come home. And the reason I know it's a selfie is if you look, there's a little air vent back there. So she was on the couch with the dog, and he has his girlfriend. We call him his girlfriend. He's a UT pillow that he slept with, and they both slept with. And so he would go to her room and take things off of her room, out of her room. So that was her dog. She was very responsible for the dog. She bought him special food. She had bark boxes coming to the house. She had him tagged. She had all of these things. She was very particular. I could not feed him anything strange. The child couldn't cook, but she would cook for that dog. She made him a special birthday cake out of special whatever it was. So it's very interesting.
I'm
Yeah.
sorry to interrupt you.
Yeah.
I mean, I think of.
I could talk about Alex all day. Ask anybody at the grocery
And I-
store or any store I ever go
I
to.
don't
so.
mean to cut you off, but I could talk forever about my dogs. But tell the jury, was Alex born on May 1st, 1998?
May 1st, 1998.
And was there anything special about her birth for you?
For me, I had ovarian cancer when I was younger. And so I had ovarian cancer when I was younger. And so I had my older 2 children, and then I ended up meeting Alex's dad later on, and we had Alex. And then I always tell everyone I was in my late 30s when I had Alex. When in fact, Alex was born on May 1st and I turned 40 on May 7th. I think it sounds better to say late 30s. I felt like it sounded better for everyone who was judging. So I thought I am in my late 30s when I had my daughter. So yes, that is what is special about that. Other than her being what I call a miracle, because we had a couple of miscarriages before we had her, and I didn't have everything because I had ovarian cancer. So she was what I'm going to call a very special gift from God.
Well, and that she was, and just, I believe that you stated to me previously when we spoke that some of her passions, and if you could just briefly go into just a passion of hers, just so that the jury can get a sense of what type of person.
Absolutely. So Alex never missed a day of school. She had perfect attendance from the time she was in kindergarten until she graduated high school. So never missed a day of school. And that wasn't because I said, I've got things to do. I don't have a babysitter. You have to go to school even if you're sick. She just had that intrinsic need she had a strong work ethic. She needed to be responsible. She just was that child. And as she got older, look, she took after me. She was not very athletic, but what she did gravitate to, she tried, but she gravitated to being an athletic trainer. So that was where she developed her passion for physical therapy. So as she made her way into athletic training, she just loved it. She thrived at doing that. And so because of that, she said, Mom, I didn't know anything about that when in junior high. So we tried to get her in volleyball, but Alex was 5'1", 5'2", so she was tiny. She never, she really wasn't going to be that kind of athlete in volleyball. I mean, it just wasn't going to happen. So when she found and discovered athletic training, she developed a program for the middle school to present. So she took it to her teachers and she said, what if? And so she was in the New Braunfels paper about developing this program for the junior highs or for the middle school, so they would know what opportunities they had. You may not be great in athletics, but you can still be a part of the athletic program. She was really proud of earning her Letterman's jacket, and all of these athletes, and Alex has got her Letterman's jacket. It just made her feel a part of, and that just what she told, and the message she sent is, you don't have to be your atypical athlete to be a part of something bigger. And I think that message resonated with her. I work with children with special needs, so she would go with me and obtain her community service hours to earn her cords for the different programs she was in, and the National Honor Society and different things that she was in. And she loved it. She would go with her dad, and I would go out to different places, and she would volunteer to participate in these programs for the special needs, different events for the children. She did the buddy walk with me for Down syndrome children. She just loved it. And I think that was really what meant a lot to her. And then getting into physical therapy, she saw what we do with children with physical therapy. And then she loved the athletic side of it. So she was torn, what do I want to do? So as she went to college, she went to UTSA. She received a bachelor's of science in kinesiology. And the next step for that is, of course, to go into physical therapy, a program. It's a doctorate program for physical therapy.
And I'm sorry to interrupt you again. I know, like you said,
Yeah.
we could go on and on
All day long.
about your daughter. But it seems to me that the way you speak about her, she gave a lot.
I think that was her. I am of a different generation. And I think because my parents live right next door to us. And so Alex was always very caring. She just was that type of individual where she wanted to make sure everyone was taken care of. So my mom would drive home from the grocery store, and Alex might be on her way to work, or she might be going to school, and she'd say, hey, Meemaw, you need help taking things out of the car, and she'd run over there and unload it. Mom would say, no, I'm fine. And she'd run over there, unload it, give her a kiss on the cheek, and away she'd go. She was very, just always wanted to give and be helpful. And even she worked at Cordillera. She worked part of the time she was going to school full time. She would work at Cordillera Ranch, and she ended up being, they call them bev cart girls. So she worked on the golf course, and she was always there, and was there in the evening also at the facility. And all of the people there, I didn't realize it, because Alex was not the type of person you'd walk in a room and it was like flashbang, I'm here. You just knew she was there, and you felt really good about her being there because she was just that quiet, confident person.
Let me ask you a question about that. With everything around her right now, and obviously this case, and obviously we're in the punishment phase of this trial, where the defendant in this case has been found criminally negligent homicide, guilty of that with a deadly weapon. How would she feel? Would she be embarrassed that people are?
She would be embarrassed. I think I hear her a lot of times because I beat a drum pretty loud for her, and I hear her go, oh God, Mom, you're so just, I was that mom who would fight for her, and she would go, Mom, it's okay. Don't worry about it. It's okay. But for her friends, she would fight for her friends a little bit like I fight for her. And I get that. Whereas she was always very caring. She was supposed to be her best friend. She was supposed to be the maid of honor for her best friend's wedding in the November, I think it was November 2nd, after she was killed. And I found this big plan. She had these plans of how she wanted to do the bachelorette party. And she had this all mapped out. And so I laminated it and framed it and gave it to her friend Liz, because I thought it was a special momentum. It was in her handwriting. I think she was so caring. She was so kind. And she just she signed everything with a heart. And I have the little heart with Alex on it. You can take, I didn't know this. I've never had a tattoo before in my life, but and I'm opposed to them. I'm going to tell you right now, but I did have the copy of it, of her signature placed on my wrist, because that is how she felt. She had the heart, and it was Alex, and everybody just loved when they got something special from her. She has 3 nephews, and she would always pick the best gifts for them, and they would just love Aunt Alex, because Aunt Alex was about their size. I mean, she was little, and so she would do things, and any toy that they got, she would try it out first, and we've got videos of her trying out toys. But yeah, she was a very kind and giving young lady.
In fact, she was such a giver. I believe that she chose to beforehand to donate her organs.
She did. She was an organ donor, and that was very hard for her dad. It was hard for me too, but I think I approached things a little differently. Her dad could not make a decision. He was the first to arrive at the hospital, and my son, I called my son. I was actually away, and when I got the call in the middle of the night, so I called my husband and my son, and they both met at the hospital together. And they kept calling me. It took me, I think Mom and I drove back very quickly. We were in Louisiana, and we drove back in 5 hours. That was pretty good timing for getting back from Louisiana. And I got back, and they kept calling me, when are you coming? When are you coming? And so I will say that Alex, I'm going to say that God allowed her to hold on, because her dad would have been devastated if he'd have been the one to make that decision. I'm going to be honest with you. And I think for us, I needed to wrap my head around the totality of what had happened to her, and the damage done to her. And so what I wanted to do was give Alex a chance, because she was pretty much, you just never knew with Alex. She was pretty tough. And when it was finally time, I said, okay, and we donated her organs. So I think that for that reason, Alex is continuing to give, continuing to be there. And I'll be honest with you, Alex took that photo that y'all keep looking at that was in her text message, and she took that photo, and I feel like she's here representing herself, because she did take that photo herself and said, gosh, look what's going on here. I don't know what to do. And she drove that highway frequently, because she would go to Josh's, she would see her friends. And so she took that photo, and I'm going to say that that's been referred to by the defense as well as the prosecution. And I'm going to say that Alex has participated in this, and I'm going to give her points for that, because I know that she's here. Yeah, for sure.
That's state exhibit number 7.
Yeah. And so for me, I know that y'all heard about that with Josh, right? And Josh was devastated. He saying, for example, my husband will say, if I hadn't have bought her the dog, she wouldn't have wanted to come home. Josh says, if I'd have just gone down there and hugged her for 5 more minutes, then she would have been behind Mr. Castro when he left Hills and Dale. If that would have been the case, she wouldn't have been on the road. She would have been behind him, and none of that would have had, but we continue to look for answers. I'm going to be honest. The what ifs, I feel like I remember seeing her, tracking her and seeing her at Josh's and saying, okay, she's at Josh's. And I would watch her. And when I saw her car on 281, I thought, oh, good, she's on her way home. I'm okay. And as it turns out, I realize now she was on 281 where she was hit. So I think there's a lot of things we look at and we think, you never know. But I do think she was a gift. I think she had a lot to offer. I think she was just getting started. Her life was just getting started. Her dad, I say she had worked off and on for years at Cordillera while she went to college, and she had saved money, and she was planning for her dad to build her a tiny house on our property. And someone asked me, oh, she was going to build a tiny house. I said, well, it was really for her dad. And it was for her to live in the big house, and I was going to go to the nursing home, which was fine. I mean, that was just the way it was with us. So yeah.
Well, ma'am.
Yeah.
You had a lovely daughter.
I did.
You have a lovely family. Thank you very much.
No, I appreciate you allowing me to speak, because I will tell you, you're not the only person I'm going to talk to about her. I talk about and I'll probably talk about her until I can't talk anymore, but I keep her always.
Well, I'm gonna go ahead and pass the witness.
Okay.
Defense may have some questions. for
Sure,
you.
absolutely.
Defense?
Yes, Judge. Miss West, Miss Sayberg seems like she was an incredible and wonderful young lady, and we are so deeply sorry for your loss. We have no questions, Judge. Pass witness.
All right, you may step down.
I appreciate it. Thank you.
That's Dave. Call your next witness.
State restaurant.
All right, ladies and gentlemen, we're going to take a 10-minute break. You are not allowed to start deliberating. I'll let you know when it's time for you to deliberate. So is 10 minutes enough time if anyone needs to take a break? All right, everyone, please rise for the jurors.
Well, that was sad. Absolutely devastating for the defense. The defense handled it well. Let the female attorney stand up. Yes, who's much softer, much more likable than the other attorney. Say something nice and sit down. I give them credit. Sounds like she was a really, really cool person. Her mother was absolutely charming. I don't know what the defense is going to do here in terms of, it's kind of strange. Because I'm not used to this phase, so I don't. Just by standard rules, the defense would have a chance to call witnesses and do things now, but I don't know what they would do. Maybe they'll call his mom and have her say he's really a good boy. He didn't mean to. Yeah, it was smart on the defense side. When you have that, you can't make points here. They recognize that. They're pros. Good on them. That's what we technically call in the law profession eating a shit sandwich. Sometimes you have to. Sometimes you have to do it with a smile on your face. But some things you can't argue your way out of. The end. Yeah, I know. I have a way with words, don't I? No. Seriously? Do you like look these things up and find background information or something? Sounds like something I should do. Yeah. Absolutely. That's for the channel. For the firm, it's Yesenia. Either way, I'm not doing it. I just checked in with the firm. Namely Yesenia. We're contemplating doing a Ask Yesenia Anything. What's it like to work for Law Talk with Mike stream? Over on Vlog Talk with Mike. Your source for all things Flamingo. That's funny.
Exciting and new.
I wonder if they'll have him testify. You just get up and go, oh, gee, I'm sorry, I didn't know. Terrible loss. Blah, blah, blah. But he probably has prior convictions that he'd eat. I don't know the rules on that because I don't know how that works with a penalty phase jury. Isn't that rising? When he does, it's grand rising, I'll tell you that.
Question at this time. Because as the defense, we are saying that we are not asking for the sequestration. The reason for the request is because we believe that based upon the juror's prior experience, if we get done with this at 6 o'clock, they'll come back with a verdict at 6:15 because they do not want to be sequestered. It could influence their verdict in an improper way. Their belief that what happened yesterday would happen today. And we would have no problem with the court explaining to the jury if they're going to go back at 6 o'clock that they will not be sequestered at 6:15 or sequestered at all, and they'll be allowed to go home if it comes to the end of their deliberations and there hasn't been a verdict. We believe that this is important to ensure that there is not a quick verdict in order to avoid that sequestration, since we are not asking for the sequestration.
Right, and counsel, as I'm sure you're aware, the request that a jury be sequestered may be made by the defense or the state. So just the defense alone stating that they're not going to be asking for sequestration is not something that the state may be requesting.
Yes, Your Honor, I apologize. I have conferred with the state, and my understanding is that they are not asking for a sequestration either.
All right. We're going to have the jury come in, and then they will be allowed to deliberate. All right.
Your
All
Honor,
right,
just, I'm
let's
sorry.
line the jury up, please.
I apologize. And just so it's clear for the record, so my request is.
I am not going to tell this jury that they will not be sequestered.
Yes, Your Honor.
The jury is going to be allowed to deliberate, and we will see where we are at a specific time.
Yes, Your Honor. I understand.
Thank you.
Thank you.
Maybe don't be a jackass to her earlier in the day.
Oh, and defense, do you have your witness
Just a
ready?
thought.
Yes, Your Honor.
All right, do you want them to go ahead and take the stand?
Yes, Judge.
It's actually a fairly reasonable request, but she's just like, I don't care. I'm not listening to you anymore. Unless I absolutely have to. And I don't blame her.
There's a hump at the very bottom. I always try to forewarn people because sometimes it jerks the seat. Yes.
All right, for the jury. And state, do you want to turn off the? Go ahead.
Oh, yeah, sorry, Judge.
That's okay.
You asked me a question I didn't know how to answer.
All right, everyone, please be seated. And state, can you rest?
Yeah.
All right, defense, call your witness.
Yes, Judge, we call Irma Rodriguez.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record, please.
Rodriguez.
All right, defense.
Yes, Your Honor. Good afternoon, Ms. Rodriguez. What is your relationship to Alex?
I'm his mother.
And how old is Alex?
38.
Now, I want to take you back a little bit for the jury to really get to know who Alexander is and his upbringing. What was it like when Alex was a young child?
Alex entertained himself. He was not a nuisance. I thought he was a perfect child. So he was a good kid.
And when he was younger, were you and his father together?
No, not biological.
Can you explain that to the jury?
His dad now is not his biological father.
What happened with his biological father?
When I was pregnant, I left him because he was not willing to settle down.
So during Alex's formative years, did he grow up with a father?
Yes.
And who is that?
Billy Rodriguez?
Is that who Alex calls dad?
Yes.
But Billy is not his biological father.
No.
Now, after Alex was a child, what was it like when he was in high school?
He was just a normal kid. You know, hanging out with his friends whenever he could and going to school, trying to get him to do his homework, keeping up on it with his grades. And
Did he meet his now wife, Christy, when he was younger?
yes, I believe that they met when they were like in the 5th or 6th grade.
And did they have a child together?
Yes, yes.
What is the name of that child?
Caleb,
How old is Caleb now?
20.
Does Alex have any other children?
They have a daughter,
What is her name?
Aubrey,
And how old is she?
16.
So you have two grandchildren from Alex that are 16 years old and 19 years old. And what is Alex's relationship with his children?
He does everything with his kids. You know, I remember when the kids were younger, especially when my grandson was born, because my first grandson, he meant the world to me. And it was really, we would have to ask Alex and Christy if we could have the grandchildren come over because they did everything together and they're still like that.
What about his daughter, Aubrey?
She's very smart, very beautiful and very bright. So, and she's so attached to her dad.
Is she in high school?
Yes.
Where does she currently live?
Well, she lives in Shirts with her mom, but spends a lot of time with Alex in Universal City at his house.
And so Alex and his wife are separated, is that right?
I believe so.
They still co-parent with both of their kids.
Yes.
Now, throughout this trial, we haven't heard from Alex, but can you kind of describe to the jury what kind of person he is, as in, is he quiet, and can you describe him that way?
He is very quiet. Alex is very reserved. He just doesn't think that it's, my opinion, that it's necessary that he has to share whatever happens or whatever he hears. He keeps everything to himself.
Has he always been reserved?
Yes, he has, except whenever there's a situation he wants to talk about, or other than that, we have to ask him questions to find out.
And you've been here with him throughout this entire trial.
Yes.
Mr. Rodriguez, you understand that the Sabert West family has suffered a great loss when they lost their young daughter.
Yes, yes, and I'm sorry for your loss. I'm a mother, so that's all I can say. Nothing will bring her back, but I am sorry for your loss.
Your Honor, we pass the witness.
Any questions?
Yes, Your Honor. Thanks. Mrs. Rodriguez?
Yes.
I'm Jason Garrett, I'm a prosecutor for this case, or one of the prosecutors, with Daniel Escobar. I have a few questions for you. One, I believe you stated that his children are 16 and 20, is that right?
Correct.
Okay. So they're one's still a minor, 16, but she's 16 years old,
Correct.
and she does a lot of stuff with her dad.
Yes.
You know, you heard Barbara West get up there and talk about Alexandra,
Yes.
about what she did with her dad,
Correct.
and how like she'd like to go shopping on Thursdays with him. I'm sure that probably your son does that with his daughter, certain things. Is that right?
Yes.
And you are aware that Alexandra was never going to be able to do that with her father ever again.
I am.
And you do
I
realize,
am.
you do realize that your son is still around.
Yes, I am.
Even if he goes to prison, he's still going to be around.
That's correct.
And that someday he'll be able to get out of prison and go hug his daughter.
That's correct.
Both his children. In fact, he had an opportunity to have kids. You're aware of that too.
I
He
didn't.
has kids, right?
Yes, yes, yes.
You know, the young lady that was killed for this criminal negligent homicide never had the opportunity to have children.
That's correct.
And did you talk to your son that night after it happened?
Not that night.
Talk to him the next day?
Yes.
Did you say he was at bars?
No.
Say he was drinking?
No.
Did you say that it was his fault that this accident happened?
No.
So he said he wasn't drinking. He said it wasn't his fault.
He didn't say it wasn't his fault.
Okay, whose fault was it then?
He came over and told us that he was in an accident,
He didn't
and
have
that a young lady had died, and he was crying. And that's one of the very few times that we see an expression like that from Alex,
Was he
because he's
crying?
very reserved.
Was he crying because he was scared that he was going to go to jail possibly, or was he scared, sad that a woman died?
Because somebody died.
Well, you've seen the videos. You've been inside this courtroom the whole time this has been going
That's
on.
correct.
Did you see any emotion on any of these body cams of him at the scene?
No, I guess I didn't, but he didn't know that there was a young lady that had passed away, according to the witnesses.
Who saw this vehicle?
I did.
He saw that vehicle.
I-
In fact, he took a picture of it at the scene.
Okay.
You saw that, right?
No. Have I seen the picture that he took?
Yeah.
No,
Okay, but you know he took a picture.
I think I saw it on the video.
You know from testimony that he realized that somebody was seriously injured. In fact, he told USAA that he believed that somebody died. Just 6 days later.
What's your question?
Well, my question is that you said he was very emotional when he came to talk to you the next day,
That's correct.
but he wasn't very emotional when he gave his statement to USAA.
I wasn't there.
You said he was quiet and reserved.
Yes,
He doesn't share much with others.
correct. That's just his nature.
So he's reserved and quiet. So you saw the body cams. Was that how your son usually acted? Or do you believe do you know if he was drinking that night?
I don't believe he was. He's not anyway, no, I don't. And his truck had just rolled over. And I mean, no one can tell if he was injured or not. I don't think anybody even asked him. I don't know.
Well, they asked him actually at least 2 times that I recall on body cam, where it came into evidence that he was
Okay.
asked if he'd like to see EMS or get EMS to check out. And he goes, no, I'm good. So you're stating that you don't believe that when he told the police officers that night that he drank 4 to 5 beers, you don't believe that he was telling the truth?
Objection, Your Honor, speculation.
That'll be overruled.
You can answer the question, ma'am.
I don't believe I heard that testimony.
Okay. Well, if I'm telling you that's what an officer stated on the stand, would you call that, what would you say? Would you believe that or not believe that?
I would say that I don't know. I wasn't in here and I didn't hear that.
Well, you did hear your son blame the Honda came into him, slid into him.
Yes.
Is that what he-
Yes, I heard.
Did he tell you that?
No,
So he just told you, I got in an accident, somebody died, and he said that the next day.
the next morning he came over to the house.
Would that be the morning that the accident happened or the next day?
I think it was that morning, maybe later on. I really can't recall.
Yeah, do you have any other children other than
I do. We have a younger son.
the younger son? And then you have a granddaughter that's 16,
Correct.
and I'm sorry, was that a grandson or granddaughter that's also 20?
Grandson.
Grandson? If somebody on the highway ran into one of your children or grandchildren going 90, and they never hit the brakes, they don't take any evasive action, and slice through their car, and then blame them for everything that happened that night.
Objection, Your Honor, speculation, argumentative.
I'll hear the question and then I'll hear your objection.
Yes, Judge.
And then blame that person that got cut down for everything that happened. And then actually lie about it and say, well, I didn't see them. But then later on says, well, the Honda slid into me.
Objection, Your Honor, compound question.
I'll
that'll
withdraw
be
the question,
sustained.
Your Honor, and rephrase.
Your Honor, we'd ask for an instruction, disregard that question.
All right, ladies and gentlemen, you're instructed to disregard that last question and the objection to compound question that will be sustained.
Your Honor, we move the mistrial.
Denied.
Same facts of this case happened to one of your grandkids. What would you want to see happen to the defendant?
Objection, Your Honor, invading the providence of the jury. It's speculation as well, Judge.
With regards to speculation, that will be sustained. With regards to invading the province of the jury, that will be overruled.
Your Honor, may we have an instruction, disregard that question?
All right, ladies and gentlemen, you're instructed to disregard the last question. State, if you'll restate your question, please.
Your Honor, removed from his trial.
Denied.
Your son ever lied to you?
Objection, Your Honor, and proper character evidence.
Overruled.
Let me look an answer.
Yes, you can answer.
What was the question again?
Your son ever lied to you?
I'm sure he has.
Does your son drink?
Actually, very little. Both of them. Bless him.
So he stated he was drinking that night.
He didn't tell me that he was drinking.
So you don't believe that?
Objection, Your Honor, asked and
I don't-
answered.
Overruled. You can answer.
Ask the question again.
Well, ma'am, I just find it odd that your son was in a fatality
Objection, Your
accident.
Honor, argumentative.
All right, let me hear the question and then I'll hear your
And
objections,
counsel
counsel.
testifying, Judge, just the way he started his question about what he thinks is odd.
All right, that will be overruled. I'll hear the question and then defense, you can make your objection and the court will make a ruling.
I find it odd that your son did not share you any specifics or any type of details about a crash where a young lady died and that he was involved in.
Objection, Your Honor, argumentative.
Overruled.
And counsel is testifying, Judge.
Overruled.
You can answer the question.
Like I said earlier, he's very reserved. He doesn't share a lot of information. That's just the way he is. He's always been that way.
And is that with everybody? Including you?
Yes.
So like the police officers, he wouldn't be sharing information or
Well, I mean, if you ask him a question, he's gonna answer it.
that's what it's young.
Nothing further, Judge, may this witness be excused.
Is the witness excused?
Yes, Your Honor.
All right, you may step down. Okay. Defense, call your next witness.
Defense calls Bianca Zapata.
Oh, sweet Jesus. They have more. That didn't help them at all. Not at all.
Can you raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand if you state your name for the record, please.
My name is Bianca Zapata.
Judge, before the witness testifies, can you approach?
Yes.
Yeah, and that's honestly probably not a bad idea, although you want better witnesses. This one looks more promising. Yeah, agreed. And you think they might have mentioned that in prep.
Step down.
All right, state, do you have an objection to Miss, I'm sorry, to Officer Zapata?
Yes, Judge, the state back in August of 2023 filed a request for defense to give us, any written notice of expert witnesses. The defense never responded to that request. We just found out today that they were planning on calling this expert witness. The state's concern is that at this time, we've been given no notice as to exactly what she's going to testify about. This is a field of expertise that Ms. Zapata, over years of working in. the very
Expert
system would
witness.
Have. It's not something that the average lay person would have, so we would object. And I can tender to the court to pose my request for notice that I filed. I can also tender.
What the?
If you wish to mark it as an exhibit.
If they're offering expert opinion and that hasn't been disclosed, there
You just want to mark it as
ain't no way that's happening.
letter of the alphabet.
Yes, ma'am. I was going to say state aid. Thank you.
What's she an expert in?
And for the record, what is state's exhibit A?
Judge, it states, CCP
English?
3914, TRE 70.
I'm sorry, what's your best?
Sorry. CCP 3914B,
Bad
TRE
mic.
705B, TRE 609F, TRE 6112B, and TRE 613 discovery request.
All right, in defense.
OnStar?
Were you tendered on August 25th, 2023, state's exhibit A?
Jackassery?
Which is a request for expert witness list. Were you tendered that on that day?
Yeah, Your Honor, I have no reason to dispute that we were tendered that on that date and at that time.
So my question then is, you were tendered that, then the next.
I'm a
question is-
boozologist.
The next question is whether or not you provided notice to the state of this witness.
Your Honor, I believe the under strict reading of the code that notice is required 20 days before trial. And we
Everything
did-
you want to know
we
about
did provide
Honduras, but
notice,
we're
I
afraid to
guess,
ask.
Today, that I provided earlier orally. What
So
the,
I just want to take this step by step.
sure.
So number one, the state requested that the defense provide a witness list of any experts. And that was done in August of 2023. Is that correct?
Yes, Your Honor.
And the defense, you received that notice.
Yes, Your Honor.
Next question. Did you provide before the day?
She has a brother-in-law named Jeff.
provide The state with any notice of an expert witness?
No, Your Honor.
All right. And the jury went out for deliberations yesterday. Was any notice provided to the state yesterday of an expert witness?
No, Your Honor.
And when did you provide the state with notice of your intention to call an expert witness?
Roundabout
Roundabout.
45
He did.
minutes ago, before the state began their
Okay,
case in
today.
chief and punishment, I believe.
Now that I have the facts, the court will hear argument and the court is.
Oh,
aware of
geez,
what
just
the
bar
case
it
law says
now.
In regards to.
I told him
notice
today.
Of experts, when they need to be provided. and
Are you
when they should
shitting
be
me?
requested. The court is finding that the state made a timely request for a notice of.
We're gonna
any
call Kim
expert
Karen
witnesses
next.
By the defense. The court is going to find that the notice that the defense gave the state today, 45 minutes ago, is untimely notice of their expert witness.
Yeah,
Now
you
the
think
court
so?
will hear argument as to why I should or should not allow the defense's expert witness to testify.
Yes, Your Honor. So I,
I'm one more point, so that the record can be clear. And the court is assuming, if I'm incorrect, let me know. The court is assuming that the previous witness, Officer Zapata, is being offered as an expert witness.
yes, I think under the common understanding of what an expert would be, it would be to testify about probation conditions, what conditions there are
My
available.
question is, are you offering her as an expert witness?
I don't know that I would formally tender her, but I would agree with the state that she would be testifying to things that I guess would be outside of the common understanding of the jury. So
You're offering.
She's
her as
offering
an
expert opinion.
I believe so, under those.
So you have to get her qualified.
Are you offering her? As an
You have to
expert
disclose her.
Yes, under those definitions.
All right. So now the court will hear argument as to defense, why she should be allowed to testify, even though the state was not give a notice, and then afterwards say, I'll give your argument.
Yes.
All right, you may proceed.
Yes,
Go
Your
ahead
Honor.
and seated counsel.
Oh, sure. Yes, Your Honor. So, so our argument is that, you know, I went down after the verdict was read this morning and talked to Ms. Zapata and asked her if she would be willing to, once the verdict was read and it was a not guilty on manslaughter, but guilty on a lesser included. I felt that it would probably be a good idea to have an expert such as Ms. Zapata, who we've used before.
And when did you
Oh,
approach her and
bitch,
ask her
please.
would she be
No.
available? Was that at
No.
4:45
And more
minutes
no.
When the state was notified?
Yeah, so about 10:30, I think, in the morning.
All right, so you knew you were gonna call her potentially at 10:30 in the morning. Why didn't you notify notify the state that you had plans, if your client were found guilty, to have Officer Zapata testify?
So it was after our client was found guilty, and when I talked to Ms. Zapata about it, she said that there are new procedures that would require a subpoena. We did not know or believe that maybe we could get a subpoena in time. We started working on the subpoena, and as soon as we ended up serving the subpoena or being able to get a subpoena,
And then the
together,
crayons ran out.
and we knew that we were going to call her, then I told Mr. Garahan that we in fact were going to be able to do so. I mean, the difference being, the difference being for me, once we didn't know if we could get an instanter done in time. And it turned out that we could. As far as that goes, it's just, I guess, counsel error. For me, if I should have.
Is it counsel error or counsel made a choice that you were seeing if this expert witness would be available to testify at 10:30, and you failed to notify the state that you were seeking to have Officer Zapata testify as an expert witness?
Well, I think that my understanding of how, and this was my error, my understanding of how this would go is that it would not, at the time, I was not, I did not know how long that this would go, and I did not know how long it would take to get the subpoena. And so now that now we've gone here enough time for our paralegals to be able to get a subpoena.
Do you think it's fair to drop an expert witness on the state during the punishment phase? You knew potentially that if you could get a subpoena served, that you would be calling this witness, and you knew at 10:30, and you still didn't inform the state.
Well, I guess I'll say that if the court is asking me that question.
Yes, I am.
Yes, so this is not an expert witness that has any kind of knowledge that the state doesn't already have.
No, but this is an expert witness that you're calling. Otherwise, what is the point of people filing motions, asking people to let them know who their expert witness is, if nobody's going to abide by those rules? They're just going to come in and say, well, I decided to call this witness 45 minutes, at 10:30 a.m. Now, and drop it on you.
I understand the court's point. I guess what I would say is if I were telling them that a neurophysicist was about to be called to testify to his brainwaves, I would agree that they would be completely on their back foot.
But here's the thing, you don't get to decide.
We're on that
when
edge.
A party requests notice of expert witnesses. You do not get to decide what kind of expert witnesses it is. So if the state were to drop an expert witness on you right now and did not give you notice of it, you will be arguing something different. State, what is your argument?
Your Honor, again, I filed this in August of 2023.
Bitch, please.
This is almost a full year ahead of this trial. They've had ample time to respond to this. From the beginning, even with the charge of manslaughter, probation was always still available to their client. They could have always said that we plan on calling someone from the probation office. It's something that, again, this is possibly second to last or last witness that they may call. And we had no notice that they were going to be calling this witness until about 30 to 45 minutes ago. Again, the state's objecting. Just out of fairness, we've been providing lists of expert witness lists for almost a year. We've been giving that notice to the defense. I believe we have been starting it since almost a year. So we've been more than forthcoming about our witnesses and our experts. So again, it's something that we would just ask that she not be allowed to testify.
All right, state, I understand, your concern. And yes, you should have been given notice of this expert witness. However, part of
Oh no,
Part
she's
of
gonna
the
allow
court's-
this. I would say get the hell out of my courtroom right
purview
now.
is to make sure that Mr. Castro has a fair trial. What I'm going to do, state, if you would like to continue this to tomorrow to speak with the expert witness before they testify, we can. Or if you would like to speak to the expert witness now, I will give you opportunity to do that.
Can I just one moment?
Yes.
You got to be kidding me. That's a horrible ruling. I love Judge Boyd, but it's a horrible ruling. I mean, in fairness to the defense, their slightly less incompetent attorney with the charming accent couldn't be here today.
Exciting and new.
Judge, we'll finish today. We can talk to Ms. Butler.
All right, then I'm going to give everyone a brief, well, not really a brief recess, but state you will have opportunity to speak to the expert witness as long as you need to.
Thank you, Judge. Thank you.
You're welcome.
I will never stream a trial again for as long as I live. This is it. This is the last one. In the pantheon of bad Mike Gravelin decisions, this is near the top. You start out with, getting married. Let's put that number one, obviously. Law school is probably number two. And then this trial.
Which is number one, wrong.
What's she gonna say? He was a good boy on probation? What the hell is she gonna say? You're probably right. You're probably right. Indeed. Now I'm getting tired and cranky, and this and Law Talk with Mike is getting, well, it's been for days, just a little too real, you know? I hear this in all these cases. I look in a criminal case, they appeal almost every time. They always do. Of course, they're always trying they're always trying to win, and if not win, junk up the trial so you have some issues on appeal. That's always the case. You got to know this. You also have to have the confidence that they didn't disclose an expert until 45 minutes beforehand. No. Hard no. That's going to hold up. I can't believe it. That's a reasonable question. I know you're trolling me, but you're also right. Oh, well, thank you. I got all the way through Daryl Brooks, but I think this trial might end me right here. No, I'm trying to get Kim back.
All right, Deputy Laura, if you could line the jurors up. Excuse me, do you know if the state is ready, or do they need more time?
Someone's been naughty.
All right. All right,
Oh,
we're
yeah.
gonna go back on the record. State, are you prepared to proceed?
Yes, sir.
All right. Deputy Laura is gonna bring the jurors in. And Officer Zapata, if you'll retake the stand, please. Yes. I don't know, there's something going on in court. Everybody has a cough now. You know, they've never changed. I don't think they've ever changed the filters at this courthouse. Well, Norma, I could be wrong. So I'm not gonna put that out there. Maybe they have changed and we just don't know. We're ready.
All right, for the jury.
Everyone, please be seated. Officer Zapata, you're still under oath. Defense, you may proceed.
Yes, Your Honor. And before we begin, we would just ask the court to take judicial notice that the defendant has filed a written sworn motion for community supervision stating that he has never been convicted of a felony.
State.
We believe that he has filed that.
All right. Then the record will note that that has been filed.
And we are just asking for judicial notice on that matter.
The record will note that the defendant has filed a document stating that.
A sworn document. Yes, sir. Thank you. Ms. Zapata, first of all, I guess, could you please just introduce yourself to the jury?
My name is Bianca Zapata. I work for the Bexar County Community Supervision and Corrections Department, otherwise known as adult probation.
Right. And can you tell us what, I guess, what your position there with probation is?
So I'm the supervisor for the court liaison officers. So every court on the criminal side has a probation officer assigned to that court. So my role is I supervise all of the probation officers that are over in the felony courts.
Now, as far as probation, can you give the jury an overview of what felony probation in particular, what it entails?
So felony probation, probation in general has initially when the judge orders somebody or grants probation or a jury grants probation, a person that starts supervision initially will go through an intake process, an orientation, and we will go over conditions of probation. There are some conditions of probation that are standard. They apply to everybody that's on supervision. And then there's other conditions of probation that are ordered by the court. And so our role as probation officers is to ensure that the individuals that are placed on supervision complete those conditions of probation during their term of supervision.
And as far as in your experience, have people who have been convicted of manslaughter and or criminally negligent homicide been placed on probation?
Yes.
And are you currently, or is the probation department currently supervising such people?
Yes.
So I want to talk about some of the conditions that you talked about in a felony, and we can kind of keep it to felony, and you have plenty of experience in felony probation.
Yes.
All right. So the conditions that we're talking about, does that include a person has to be monitored for up to 10 years?
So an individual that's placed on probation, if they are adjudicated or found guilty of that offense, when they're on a felony probation, they can have a term up to 10 years.
And the other conditions that are pretty standard across all probation is that they cannot consume drugs or alcohol.
Correct.
And how does probation department make sure that the person is not consuming drugs or alcohol?
So the probation officers, we do not conduct our own drug testing. So we do have a third-party vendor, an outside lab that an individual is instructed to go submit their drug test. And that's done at the discretion of the officer or as the court orders. That individual is then instructed to go to the lab. They do the UA collection and send that off for processing, and then we're notified of the results.
Is there also, as conditions of probation, can restitution be assessed to the people that have been harmed by the defendant's action?
Yes, that is correct. Restitution can be assessed, and the probation department is responsible for collecting that restitution and then dispersing that.
And as far as some of the other conditions, I guess ultimately, are the conditions of probation set by the court?
Yes.
And those conditions, can they range from a person having a curfew,
Yes.
from a person having to wear a GPS monitor,
Yes.
a person having to be frequently tested for drugs and alcohol?
Yes.
Can it also, are there conditions of probation that a person has to go serve 180 days, up to 180 days in the county jail?
Yes.
And that's as a condition of the probation, so they have to serve every day of that 180.
Yes, that is correct.
As far as the, I guess some of the other conditions, are there conditions saying that a person can't go to a certain place or certain type of place?
Yes.
And are there conditions that say that a person can have no contact with other people that they may have harmed or their family?
Yes.
And so ultimately, have you seen in your experience that people can be, that people that are successful on probation and successfully completed?
Yes, I have seen individuals that complete their term of probation.
And have you also seen people who have not successfully completed their probation?
Yes.
Now, if a person violates these rules and its conditions of probation, what does the probation department do if they find out that they've been violating those rules?
So we, to a certain extent, the probation officers can have some type of discretion in order to sanction individuals, address violations that may have occurred, but ultimately it is our responsibility to ensure that those violations are reported to the court, of course, timely, accurately, and so that can range from any type of violation. So any of the conditions that have been ordered, it would be the responsibility of the probation officer to notify the court.
And as far as once the court is notified, have you seen that people on probation that have violated their probation have a motion to revoke that probation?
Yes, there are individuals that have a motion to revoke filed.
And motions to revoke probation can, if the court determines that the person violated, if the court wants to, the court can take that person off probation and sentence that person to prison.
Yes.
And I guess whatever the underlying prison sentence was that they're on probation for, they can go for up to that amount of time.
Yes.
Now, just to be clear for the jury that I have asked you, you're normally in this 399th District Court now.
Yes, I've been covering in that court for a couple of months.
Right. And as a supervisor, sometimes you're called to go to different courts and covering courts.
Yes.
But you don't know anything about the facts of this case, and I didn't talk to you about the facts of this case at all. I'm just asking you the general conditions of probation that you're aware of.
That is correct.
All right, Your Honor, I'll pass it.
State?
I'm just curious, Ms. Amanda, when were you asked to testify for defense?
I was approached this morning.
And have you ever testified for defense counsel before?
For this defense counsel?
Yes, ma'am.
Yes.
How many times?
I believe one time before.
Oh, what type of case was that?
It was an intoxication manslaughter, if I am correct.
And talking about probation and manslaughter, how often, based off of your training and experience, have you seen someone get probation?
Oh, that was fun.
I don't see it all that often.
It's another
but there are
intoxication
individuals that are
manslaughter.
Placed on supervision for those offenses.
She didn't say another, but it was
Something
implied.
about an underlying term. Can you explain to the jury, what does underlying term mean?
So an individual that's granted regular probation, they have their underlying term, which is the maximum amount of time that that individual would serve in prison. And then they have their probation term. So you could have an individual that has a maximum of 10 years in prison that they would serve, depending on the level of offense.
Yeah.
And then they could be on probation for up to 10 years.
I would definitely be asking that.
I was, so, for example, let's say if someone gets an underlying term of 5 years and that's prorated out for 5 years, what does that mean?
So that means that a person would be on probation for 5 years.
Yeah.
And then the underlying term is 5 years. So if they were to get
Generally
revoked
can
on their
ask that
probation,
question.
they could only be sentenced up to those 5
I'm
years.
not sure in this context, but
And
you certainly can in a
Based
civil
off your
case.
training and experience, how often are people revoked whenever a motion to revoke is filed?
I wouldn't be able to tell how often. I can say that I do see people that are continued on probation and not necessarily revoked the first time that they're have a motion to revoke their probation.
And talking about revocation, has anyone, based off your training and experience, or is it common for someone to be revoked because they don't pay back restitution?
I wouldn't say it's very common.
And you talked about, you spoke about a few alcohol and drug treatment programs. Well, wouldn't someone who's going to go into one of those programs, wouldn't they need to be honest about the drug and alcohol use?
So anytime that the probation office does offer substance abuse treatment, so we do have a unit within our department that does those assessments. It is determining the level of treatment is based off of a self-report. So the individual would have to self-report their substance use, current or history, and then the assessor would make the appropriate determination on what level of treatment would be appropriate for that individual.
So if someone weren't honest about that, then there may not be a proper determination as to where they need to go.
Correct. If they do not self-report substance use issues, then the assessor may not be able to make a determination on an appropriate level of treatment.
And the defense counsel brought up that sometimes people succeed and sometimes people fail on probation. Is that correct?
Yes,
But whenever you look at someone when they're starting probation, you're never able to say whether or not they'll be successful.
that is correct.
That's what it's.
Defense?
Yes, just so I can clarify, because I think the state said it, I wasn't talking about drug treatment programs. What I was talking about, and I think you understood it. What I was talking about is on every person who is on probation, no matter what offense that they're on probation for, there's drug and alcohol testing is a standard condition.
Correct.
Right. So if it was burglary of a habitation and they went into somebody's house and had nothing to do with drugs, they would still be checked for drugs and alcohol because you're not allowed to use those on probation.
That is correct.
All right. So as far as, I guess, as far as the, well, honestly, Judge, that's all I have.
All right, state, any further questions?
Sorry, Judge, nothing from the state.
All right, is this witness excused?
Yes, sir.
All right, you may step down. All right, defense, call your next witness.
Your Honor, at this time, the only thing that we have remaining is we would just like to enter the affidavit that was signed by the defense into evidence as Defense Exhibit 4, which we
Alright.
don't have a copy of.
No more witness. Beautiful.
Did anyone ask the clerk to pull it?
She was a
didn't, Your
a
Honor.
fine witness.
As we talked about, because we just want to make sure that that piece of evidence is preserved in the record before.
She was honest and likable. She just didn't
Interesting.
testify to
All
anything.
right, so you rest?
I can't until that goes into evidence.
Well, counsel, are you going to ask the clerk to pull the document?
Yes, Your Honor. I would like to ask the clerk to do that. May I have an opportunity to do that?
Yes.
Thank you. I apologize for the delay, Your Honor.
May I approach a second?
Yes.
Just wanted you to know that for purposes of the hearing after the presence, there was already a 4. So I don't know if you need to know or if we need to go to 5.
I would be shocked if if he just gets probation after the mother of the victim testified, to be honest. But you never know. I don't watch these things. I wouldn't know. I'm just saying from my gut. He was a condescending prick yesterday and today. He's really off-putting. There's a way to you make a legal argument. You just argue your point and you say, here's why, and you cite your authority. He kept couching everything in, well, this is the way judges do it, Judge, which is just, it's wrong. It's inappropriate. And he did it like 2 or 3 times. It's going to rub any judge the wrong way. And the guy before, the guy who's on the Love Boat now,
I'm
they're
told
the
by
same
the
ones.
court reporter,
They make the right
correct number would
arguments.
be number 5.
Roughly speaking, like I can see where they're coming from legally all the
We
time,
would offer defense exhibit number 5.
but they just had really abrasive sides to them. This guy's probably worse.
This time the state just objects to your second.
Yeah. Yeah, let's have the state call a prison guard and say, have you seen some attitudes change through the years when people do some time here? How many people have been killed by inmates locked up in this facility? Oh, none? You guys have 100% success rate on people not getting killed on the roads by incarcerated inmates? Fantastic.
All right. The state is objecting to hearsay.
Yes, Your Honor. We've taken that straight out of your file as a public document. Under Rule 8038, public records are accepted from the hearsay rule. It is properly authenticated because we just all watched her take it out of your file. So we are asking for that, which establishes that he has not been convicted before of a felony, and the state has no dispute that he hasn't been convicted before of a felony.
All right, can I have parties approach?
He's been charged with a felony. But yeah, you can't get that in front of the jury. Breathe deep. You are experiencing the never-ending trial. I don't know. I didn't know anything about it. The chat was telling me that he
Right, defense.
sidestepped a
Miss Irma Rodriguez.
SA, shall we say, charge.
Irma?
All right, you're still under oath. Defense.
Oh, sweet Jesus. Why is she back?
Ms. Rodriguez, known Alex your whole life. Has he ever been convicted of a felony offense?
No.
We pass the witness, Judge.
State.
There you are.
Yes.
One, you've been in here listening to probation and everything, but, the officer testified to that. But you stated that your son doesn't really drink much alcohol.
That's correct.
So does he do any other substances?
No.
So he doesn't have an alcohol problem,
No.
doesn't have a substance abuse problem?
No.
So.
Which is number one, wrong.
Thank you. No further questions.
May this witness be excused, Judge?
State. Any objection to this witness being excused?
No objection.
All right, you may step down.
Defense rests.
All right, state, do you close?
Statements.
Defense closes.
All right, ladies and gentlemen. I'm going to read to you what's entitled the charge of the court. You don't have to memorize this. You will be given the original when you begin your deliberation. Charge of the court on punishment. Members of the jury, by your verdict returned in this case, you have found the defendant, Alexander Castro, guilty of the lesser included offense of criminally negligent homicide. Also, by your verdict, you have found that the defendant used or exhibited a deadly weapon, namely a motor vehicle, during the commission of the offense of criminally negligent homicide. It is necessary that the jury assess the punishment for this offense. You are instructed that the punishment for criminally negligent homicide, where it is shown on the trial of the offense that a deadly weapon was used or exhibited during the commission of the offense, and that the defendant used or exhibited the deadly weapon, is confinement in the Texas Department of Criminal Justice Institutional Division for any term of not more than 10 years or less than 2 years. Therefore, you will assess the punishment of the defendant at any term of not more than 10 years or less than 2 years. In addition to imprisonment, the defendant in this case may be
he's got a
punished
minimum.
by a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. If you assess a fine, it is not paid to the victim, if any, but is paid into the registry of the court. The defendant in this case has applied on written sworn motion for community supervision, stating among other things that he has never been convicted of a felony in this or any other state. Our statutes provide that where a defendant is found guilty of the offense of criminally negligent homicide with a deadly weapon, and they further find that the defendant has never been convicted of a felony in this or any other state, the jury may, within its discretion, recommend community supervision during the good behavior of the defendant. If the jury does recommend community supervision, it will be granted by the court. If there is any evidence before you that the defendant may have previously committed an offense or act of misconduct other than that for which you have convicted him, you are instructed that this evidence, if any, was admitted to assist you, if it does, in determining what sentence is appropriate in the case at hand. You may consider that evidence in assessing punishment only if you first believe beyond a reasonable doubt that the defendant committed such other offense or act of misconduct, if any. In the event you have a reasonable doubt as to whether any other such offense or act of misconduct was committed, or as to whether the defendant was involved in such other offense or act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any such matter. You are instructed that under our law, no evidence obtained by an officer or other person in violation of any provisions of the Constitution or laws of the state of Texas or the Constitution or laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. Therefore, if you believe or have a reasonable doubt that the evidence was obtained in violation of any provisions of the Constitution or the laws of the state of Texas or of the Constitution or laws of the United States of America, In such event, the jury shall disregard any such evidence so obtained. You're instructed that unless you believe from the evidence beyond a reasonable doubt that any statement introduced into evidence was freely and voluntarily made by the defendant without compulsion or persuasion, or if you have a reasonable doubt thereof, you shall not consider such statement for any purpose nor any evidence obtained as a result thereof. You are instructed that the defendant may testify in his own behalf if he chooses to do so. But if he elects not to do so, that fact cannot be taken by you as any circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a punishment verdict in this case. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if sentenced to a term of imprisonment, because the application of that law will depend on decision made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. A suitable form is attached hereto for your verdict if you should care to use the same. However, such form is not intended to influence you in any way in arriving at your verdict. In any event, your verdict must be unanimous, in writing, and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. All right, each side you have 15 minutes. State, are you prepared?
State reserves full time for me.
All right, defense?
Yes, Your Honor. May I have a moment to set up the technology?
Yes.
Thank you, Judge.
And would you like a time announcement?
Yes, Judge. May I have a 5-minute warning?
Yes.
Oh, great. Now we're going to have a lame PowerPoint that we can't even see. Bubba was a good boy.
We asked you to follow the law.
He likes puppies.
Know that you did. We understand your verdict and we respect your verdict. Thank you for looking at the evidence closely and for taking that time. Now where we're at today, and right now, is the punishment phase, deciding where Alex will be for the next part of his life. That's what we're here for right now. Talking a little bit about the range. Yeah. Yeah.
And defense, I paused your time.
Thank you, Judge. I'm sorry about that. Okay. Thanks. The range is 2 to 10 years in prison or probation. And we're asking you today to give Alex probation. And I'm gonna walk you through why he should be given probation and what that means in context. Right now, what we just heard is punishment. And the state, this table over here, is allowed to bring you any bad thing that Alex has ever done in his life. They're allowed to bring to you any person that he has hurt. What we heard right now is that they brought you the worst thing that he has ever done in his life. They brought you one night to depict what you should do for the rest of his life. Now, we brought his mom today. We didn't bring her to excuse his behavior or to defend him. I know she got a little defensive up there. Of course she is, that's her son, and she is scared to lose him. So please do not hold that against Alex. We just brought her to testify a little bit about his life and who he is as a person and his own family. What we know for a fact, and I don't think that can be contested by either side, is that Alex never meant to hurt Miss Saber, and he never meant to kill her. He never meant to hurt anybody. This is not an intentional act that happened. We know that. Now, when you go back there and deliberate, this will be in the charge, and it says that it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of individual jurors, meaning cannot be determined, okay, you want this number, I want this number, let's just do this number. The evidence has to be analyzed by each and every one of them. You will also read in the charge that you can, or you should know, that there is parole law. There is a certain time where someone is eligible for parole. But it's also in the charge that you should not use that in determining what kind of sentence you want to impose. And the reason for that is we do not know what the parole board would do. We do not know if they will deem someone is able to leave at half time, 75% time, or even the full time. You should know that whatever sentence you give, if you go that route, will be the full time, most likely. Now, context, this is where this comes in. A 10-year term in prison means that Alex has extensive criminal history. He's been a felon. He obviously is not. We brought that before you today. That's what a 10-year sentence looks like. That's somebody who's been in trouble with the law, who is a felon, and has had second chances. That's not Alex. It's also maybe somebody with a history of reckless driving. Could be, they could have brought to you his driving record that says, okay, he's had 5 tickets for speeding, he's had this many accidents, he's done this, that, or this with other people. He's hurt people before, people have had to go to the hospital. And that is not the case today. Alex does not have a history of reckless driving that has not been brought before you. That is also what a 10-year case would look like. If you've heard evidence that this has been an ongoing issue in his life, that this is not the first time that this has happened. A 5-year case, somebody who's had prior second chances, somebody who's been given out an opportunity before, maybe by a jury, somebody who's messed up and has been given that chance again to redo their life. And that is not the case here. There's been no evidence about that. Another 5-year case in prison could maybe mean there's no Shayna Lassel and there's no issues with SAPD. And again, I want to remind you, we're not using that to excuse him. We're using it to provide context. If there was no Shayna Lassel, if there was no SAPD not putting warning signs, then maybe 5 years in prison would be appropriate. Because then at that point, he would have just crashed into somebody on the highway when there was not standstill traffic. Those are not the facts in this case. They are not. What we do know is that Shayna Lassel, who created this chaos, who made Miss Siebert stay there in that line, we know that she was given a citation that night and dropped off with her husband. And we know that the SAPD officers were given a suspension by the department. And now we have Alex. He's the only one over here. We heard that Alex is a dad. He has his 2 kids Aubrey, and Caleb. And we know that Miss Saberd's death, nothing can bring her back, nothing. And the pain that that family feels, we cannot even imagine. And that is not to go, what we're not trying to say is ignore that pain because he has 2 children. What we're trying to say is sending him to prison will compound that pain. And it will mean 2 other young adults, a 16-year-old girl and a 19-year-old male, will be left without their father. And what does that mean? What kind of trauma at that point will they have? We know that he's important to them. We know that he's somebody who cares for them and supports them. And that's another family that's going to be broken. So that brings us to why we are asking for probation today for criminally negligent homicide. And that is because Alex has the ability to be on probation. We did not hear of any violations since he's been awaiting on bond. We did not hear anything. They could have brought you. He failed to report to his officer. He failed a urinary analysis test. Anything like that. Any single thing that he's been watched for. Every step that he's taken has been examined for the last 2 years. And we do not hear about any mistakes that he has made. And that means that Alex has the ability to be on probation. Not one violation. Probation means, 1, after today's verdict, he's going to be a felon. He's going to be a felon for the rest of his life. That is the truth. And it also means that he'll have to report to somebody. He will have to follow all the rules if you grant him probation that this judge will give him. All of the rules. That means taking whatever classes is deemed necessary after he's evaluated, as Officer Zapata told us, by evaluated by someone who's able to make that sort of assessment, who understands what people need and what people don't. A professional. He's not going to be able to do anything or mess up, make any sort of mistakes, because he will have prison over him. He will be able to make amends. He'll be able to live his life as a good person. And he'll be able to pay restitution back. He'll be a felon, and that's something he'll have to live for the rest of his life. What happened, the Saberd's death, is something that Alex has lived for every single day, as he should, since it happened. Every single. The whole of Alex's life, again, not to excuse him, it's just to provide you some information about who he is, where he came from. Aubrey and Caleb. That is one of our biggest reasons that we are asking you to give him probation, to allow him to continue being a father for those 2 children that did not have anything to do with this. Prison means sending him away, means he will be locked up for one mistake that he made in his life, which is the death of someone. Means he will not have any ability to provide for his family. And it means that a 38-year-old man, in addition to a family that's already lost, we're also going to lose another. No second chance provided to him. So that's why when you go back and you are looking at this verdict form, we ask that you assess punishment between 2 to 10 years. And that you fill out one of these 3 slots where the X mark is. And they say that we have not assessed fine, and we recommend the term of confinement, where we have assessed or suspended the defendant and placed him on community supervision, meaning that you have allowed him another chance and you're putting him on probation. Rather that be 8 years or 10 years on probation. The second one means that he will also have a fine. And the third one also means that he will have a fine. But all those 3 choices, 1, 2, and 3, means that
5 minutes.
Yes, Judge. His application for community supervision has been accepted. Punishment and context. We're asking you to give him another chance. We're asking you to think about what is just in this case. We're not here for revenge. That's not what this is about. Nothing can undo what has been done. I know Alex wakes up every day and wishes he could do something to undo it. but it can't. And that's why we're asking you to grant him community supervision. Allow him to be a felon for the rest of his life. Allow him to make amends however that is. Allow him to be with his two children, Aubrey and Kayla, and not to throw him in, not to throw him away.
State,
Thanks, Judge.
would you like a time announcement?
Yeah, 3 minutes, Judge.
Mr. Chairman, can you get the mic? I think the computer is loud.
All right. Oh,
That one.
this one right here.
Yes.
Very good. All right. Well, ladies and gentlemen, I'll be the last one to speak to you today. And we're gonna go back and deliberate and determine the outcome of this trial that we've been here for. I'm gonna tell you this, that just touching on some of the things that defense counsel brought up, about no second chance, no throwaway. He got a big second chance. This individual over here has more second chances than a cat has lives. I mean, you had the police department that messed up a little bit. You have us prosecutors that might have messed up a little bit, but the fact is, he did what he did. And still, I was surprised, still blaming others, still blaming the Cicel lady. I mean, if that's the case, ladies and gentlemen, go back there right now. I'll stop. You go back there and give probation. Because they're still blaming somebody that had an accident down the road. That means every single one of y'all could have slammed into the back of anybody and blamed people up ahead. Take no responsibility for your own actions. That's what this individual over here has been doing throughout this whole trial, the whole trial. They all went back there, came back with criminally negligent homicide, 2 to 10 years. He gave them another second chance there. I respect your decision. I understand your decision. But he was facing 2 to 20 before. Now he only has 2 to 10. And they still asking for another second chance, another bite at the apple. That woman right there, that young lady will never have another second chance. This family over here will never embrace her again, ever. But let's give him another second chance to hug his daughter and hug his other daughter and hug his family and love them. But you know what? He's gonna have that chance. You can send him to prison for 10 years and he's gonna get out someday and he's gonna say, I got away with it. Because the cops messed up. Because that lady down the road got in an accident. Prosecutors didn't do a good enough job. That is done today. Done. That's Alexandra Shea West Cyber. When he met that man over there that night, that's what she ended up as. This is where she ended up. Probation. What do you have to do? What do you have to do to get sent to prison? If it's not killing someone, my gosh, where are we at in our society that we want to allow people like him just to say, hey, look, bad mistake. I'm sorry. Give me probation because I got 2 kids, one's 16, one's 20. This is a definition of substantial, not definition, but substantial risk, unjustifiable risk. A gross deviation from the standard of care that an ordinary person would exercise under all the circumstances viewed from the actor's standpoint. Let's talk about that. You've already gone over this during the for instance, but he was going 90 miles an hour, and even from his own mouth, when you talk to USAA, it was 65 miles an hour. So that's 25 miles an hour over the speed limit when he slammed into Alexandra's car. 25 miles an hour over the speed limit. And we all know, you saw the speed limits out there was 45, He knew it was under construction. You look at those USA documents, he said it was new construction. He knew all this. And still, he's blaming Alexandra for that Honda slid into me. All the evidence in this case, all of it, says he slammed into the back of that young lady and sliced through her freaking car. And in an instant, 24 years is gone. The rest of her life is gone. Let's give him probation. Go back there and give him probation. No. How? Look at everything else. No breaking. From all the evidence, no breaking at all. Scientific evidence, the math, the pictures at the scene, none of that. No evasive action. Highway was under construction. We got 45-mile-an-hour zone. And let's talk about drinking 4 to 5 beers, and it's after 2 a.m. in the morning. But it closes at 2 a.m. You've heard all the evidence. You're smart people. Y'all know. And where did that tracking send him? Where was he for those hours before he slammed his car into that car and killed that young lady? No, we can't tell you he was inside that bar. But you're smart people. You saw that tracking.
Improper argument.
All right, overruled.
He's around those bars. More bars. More bars. And at 2:02 a.m., he's leaving. Traveling down the highway like a missile going 90 miles an hour. Just waiting. When's that person that's just an unlucky person? Because this fever was unlucky. Very unlucky. The defendant said he saw an 18-wheeler, said he saw the Honda slide into him. At times he said he didn't see it. Things that he says and other people saw, taillights as far as the eye can see. Remember Josh's testimony. As far as the eye can see, taillights. Everyone else saw it. Everyone. Because there's only one person that slammed in the back of her car or anybody else's car that night, and it was him. And he wants probation for it. Even two of the vehicles, an 18-wheeler and the car right behind the 18-wheeler, which he said he was behind the 18-wheeler, I might add, had their hazards on. You saw the picture. There was a clear line of sight for half a mile. Blame the victim again. Blame the officers. Blame the other driver. Everyone else stopped. Everybody else slowed down. Everyone else avoided a crash. Everyone else noticed the traffic. Everybody else knew the risk of driving on a highway, especially going at a speed of over 90 miles an hour and not hitting the brakes. She slowed down. Alexandra did. Everyone else except for this man, this defendant that's asking you for probation for killing a young lady. He was concerned. What was he concerned with? You saw the body cams. Watch him get it if you like. But I'll tell you right now, he was concerned about his golf clubs. Carrying those golf clubs around. Dropping them. Those officers messed up. I agree. They messed up big time. Let's not mess up again. This man deserves 10 years. What was he doing literally minutes after the wreck happened at 2:21 a.m.? Calling his wife, come pick me up. That was on body cam. You heard Paul Martinez testify that he called his wife. He let him borrow his phone. Minutes after, he's worried about going home, getting his golf club and going home. Not caring about anybody else but himself. At 2:36 a.m., Alexandra is still at the scene. And he just arrived at 2:38. She's over there lying in a pool of blood, breathing her last remaining breaths. And he's calling his wife saying, I need to get a ride home now. He deserves probation. He's concerned about going home the whole time. takes photos. Photos. He wants more photos of her vehicle, like a trophy. Look what happened. He lied about hitting those brakes. He proved that. I know we're here during punishment, but he lied. He keeps lying. In fact, he blames Alexandra. He says that Honda slid into him, and he says that at 4:22 a.m. He lies. The evidence shows that he slammed in the back of that car. Stop blaming everybody else and take responsibility. I mean, Alexandra is never going to grow up. She's never going to hug her mom again. Never going to go to the grocery store with her dad. Never going to pet her dog, Blue, ever. And he wants probation for that. He took away a life. And he's only had to give up 10 years of his life. That's it. He took away 50 plus years of Alexandra's life. 50 plus years. She was a giving, kind individual that would probably be embarrassed that we're in here arguing over her and saying what type of life she led. You know, when you go back there and think about what to assess this individual, just remember those things. Our community deserves better than this. You deserve better than this. We all deserve better than this. Alexandra definitely deserves better than this, to be blamed constantly for this man's actions that night, of going around town all nights of the hour, drinking, disregarding the speed limits, the warning signs. He doesn't deserve that second chance at probation. He deserved to be sentenced 10 years in prison so that the punishment fits the crime. In fact, it doesn't, because it's only 10 years. A life was taken away by this man. Maybe he wants to say it's a mistake, or if he wants to call it an accident, that's fine. He can call it for whatever, they can call it whatever they want. But in the end, Alexandra is never going to be back. And she deserves a lot better than this. And I think our community deserves better than this.
3 minutes.
Thank you. You gave him half. He was going from 2 to 20 years for manslaughter. You gave him half already. Give him the 10 years. He deserved it. He earned it. Right there on that stretch of highway where Alexandra took her last picture that she ever took. They deserve it. We all deserve it. When you look back at this, I put 10 years. You're supposed to put 10 years. Put a check mark right here saying probation denied. It's the only proper thing to do. You gave him a break already. Don't give him another one. Thanks.
All right, ladies and gentlemen, you've heard all the evidence that you're going to hear in this case. So Deputy
done.
Moore, of course, is going to separate the two
Fantastic
alternates.
closing
All
argument
please
from the
rise for the
state.
jurors.
I liked everything he did. I would have brought up Mom a little bit because she was fantastic. I would have just reminded them of that. Did they just leave? Did they just cut off the stream? Or am I buffering? What's going on here? I don't. I heard from Debbie that they expect to maybe hear something at 10 o'clock Eastern time at the earliest. Does yeah, it's doing that, but it usually does that when it ends. Okay, so they cut off the stream. Is she gonna come back on? I hate this trial. I really do. She'll close the stream. Okay, but when is that? Tonight? Whatever. I'll try to monitor, but I'm not telling you. I've been chained to this chair all day. Well, I got the guilty verdict. That's better than I usually do. State did a fantastic job. Like I said, my only thing is I would have highlighted mom a little bit just because she was such a fantastic witness. Not gone crazy with it. That's the only different, but that's minor. Whatever. He did a great job. I didn't think the defense attorney was so bad in her close. It's just her argument was so horrible. Of the three, the female associate was far and away the best. In terms of relating to people, those other guys, those other two, they seem to be okay as a matter of law. Although I still can't believe the request for a continuance mid-trial for him to be on the Love Boat. I still can't believe that, and frankly, I still can't believe, you know. Yes, why? Yes, I do. I still can't believe that they allowed the probation officer. It was irrelevant. It didn't matter. It didn't move the needle 1 millimeter in any direction. But I'm shocked that Judge Boyd allowed them to call that probation agent as an expert. I don't think it made one whit of difference in the trial. If anything, I think it hurt the defense. But yeah, both the British guy and it's like the thing, you know, they're doesn't matter what country they're from. Both the British dude and the American dude were just abrasive as hell. They did research. They had authority. I'm not saying they're stupid, but like zero people skills, and they're freaking litigators. That's like they cannot read a room. I'm just calling it straight. Well, having said that, they actually got a good result for their client. I'm not horrified. I think that they should have gotten a higher charge, but you know, if a client got convicted of the lesser included, I guess that's a win on some level. I'll give them that. They had enough sense to not let their client take the stand. They had enough sense to soften up and let the young associate handle sensitive things because they know that they have zero personality. Both of them. I'll give them 1 point for self-awareness. They weren't out of their minds. The continuance, the taking a cruise in the middle of a trial, and then stepping up and arguing it voraciously that this is a good idea. I that to me is borderline sanctionable to even ask. It's not a hamster. I don't know. I call it my dramatic hamster. I don't know. And then through all this, although we got the verdict, we got a guilty or whatever. Now we just want to know what the sentencing is. I'll try to get to it. If I get to it live, I get to it live. But I've got to leave. I did go out and take a 10-minute walk earlier today in between. That's it. Other than that, I've been tethered here. Yep. What are the predictions here? I have no idea what a jury will do with this. They can do 10. I'll say that, I'll say they split the difference because they split the difference on the conviction. So I'll say that they give him 5 years. Fine, I don't know. I think these guys are private attorneys who had enough money to pay the attorney. We'll probably hit him with a fine. Thank you. But here we are, pushing 5 hours on this second stream of the day. Although, what happened today? I'm gonna pull that. Oh yeah, I'm gonna take that. I'm gonna take that Judge Simpson thing. Somebody tell me where it is. So I did that landlord tenant thing. I did one. There were 3 appearances. There were 3 relevant appearances on this. I come in on number 2, and then number 3 was today, and I picked it up. This Food Fairy told me it was going down. That was all that very interesting because we saw sort of a flip. We saw Judge Simpson, who believed the tenant before really getting after the landlord, and now was just every bit as mad at the tenant as he was at the landlord, knowing the rest of the story, which is understandable. I mean, he didn't make any rulings or do anything out of line, but he assumed the landlord was at fault in the last hearing for sure. And now when he finds out that isn't the case, he was not happy, which is understandable. I might put all those together. If someone can send me the first hearing, I might put all of them together in one thing. That's what's bad when I get something good in the middle of one of these trial streams, then it's like, I want to re-record it. Like I have the same thing yesterday. We had Swifty. Swifty seemed to be doing well. She was holding up well in incarceration. She does well in jail. I think we should keep her there. I really do. She had a good attitude about it. But not now. I got to pull that out and post it individually because I've got a playlist. I think it's called Swifty Gone Wild. But I got to throw that in there. And yeah, I recorded it in the middle of a long trial stream, but you know, we got to make it simple for our Swifties. They can't be finding that. You know, they can't find good music. They probably can't find a small segment of a large stream, right? This is my logic. Am I in trouble? And we've lost some along the way. I don't believe that Kim Karen's coming back. Even though I did a special pause of the music for her, I don't think she's coming back. Yeah, that was a bench trial. And then I've got outed as not particularly Taylor Swift. I've heard of worse things than Taylor Swift, but I just don't like it. It's just not my fave, you know. That doesn't mean I even think it's terrible. It's just not my cup of tea. Like I said, she's not singing to me; she's singing about me. I'm not her audience. I also got outed as an NPR hater. I'm just going to fess up to that. I can't stand NPR. It sucks. It sucks, and all their funding should be cut immediately. And I guess that's part of the irritation of it. Lots of other things suck, but they go out of business. But no, not NPR. There's all sorts of bands I don't like and radio stations I don't like and all sorts of things I like, but they really don't bother me if I'm not supporting them. Against my will. If you just want to go make bad music in the band, you're not hurting me. I'm not listening to it. But then you tell me I gotta fund it? No. That's why you whisper bad news with bad takes to me. trying to sound like you know something when you clearly don't. Yeah, that's NPR. All right, there you have it. That's all we got for now. I'll do the verdict at some point. I may not catch it live. I may do it after. I may just throw it into another stream. I don't know. They're gonna come back and say you get somewhere between 2 and 10 years, and somewhere between $0 and $1,000 in fines. That's it. That's what's gonna happen. It should happen tonight. Unless these people really enjoyed their low budget hotel. All right. I will see you all soon. I'll figure it out. I'll stream it eventually. I promise I will.